Well, good evening and welcome. I am Councillor Phil Barnett, Chairman of Western Area Planning Committee, and I'm assisted tonight by fellow councillors. Firstly, my Vice Chairman, Councillor Clive Hooker. Next door to Councillor Hooker is Councillor Anthony Amaraj, Councillor Adrian Abbs on the right-hand side, Councillor Howard Wollaston, Councillor Paul Dick, and we've got a substitute tonight, Councillor Billy Drummond. The following officers to advise the meeting or support me in the meeting are as follows. To my right, I've got Deborah Instrom, Team Manager in Development Control, Michael Butler, Principal Planning Officer over to the far right, Michael. Sean Cutts next door, a Senior Planning Officer. And to my left, I'm ably assisted by the Legal Advisor, Sharon Armour. Paul Bacchus is the Principal Engineer, Transport and Countryside. Over, hello, Paul. And next door to Paul is Paul Goddard, the Team Leader, Highways Development Control. Hello, Paul. I'm also assisted by the clerks, Sadie Owen in the far left, and behind the Zoom host is Sam Chilverton, sorry, Sam. And also I think we're supported tonight by a Environmental Health Officer, Russell Davison. Good evening, Russell. Before we start this evening's meeting, I would like to take the opportunity to remind members that we are subject to the Council's Code of Conduct, which requires us to uphold certain standards, including, importantly, respect. Members across the chamber might not always agree with one another, but I would ask that in our disagreements, we endeavour to always be respectful of others' views. And obviously for members of the public and members of the different speakers that are attending tonight that are perhaps not aware of the evacuation procedure, the evacuation procedure is as follows. If we hear the alarm, we must immediately leave the building. Please proceed via a safe emergency exit route and follow any instructions given by the officers. The assembly point is in the car park at the back of the Dolphin Public House. I hope everybody knows where the public house is. It's on the far side of the entry to this building. If the lockdown alarm sounds, we must remain seated and await instructions from officers. We will then adjourn the meeting in such a time it is safe to proceed. Do members have any questions in the way that we are going to proceed with this meeting tonight before I formally start? Shake of heads. Okay, thanks. Sadie, apologies, please.
Got apologies from councillors Denise Gaines, Nigel Foote and Tony Vickers, Chairman. Thank
you very much. Moving on to item 2, and I'm obviously going to invite members to comment on the meeting that was held on the 24th of July, which we've been supplied with minutes. Any comments on the minutes before I ask for a proposer and seconder? Any comments? I'm going to therefore propose them from the chair. You're going to second them, Councillor Wollaston. All those in favour that were present, please show. And any abstentions? Anybody that wasn't present? Okay, you got the names. Okay. I'm going to now move on to item 3, declarations of interest. Perhaps I can go around the table. Any declarations of interest, Councillor Drummond? Councillor Dick?
Chairman, I have been lobbied by a large number of residents, but I'm confident that I will be able to make a fair judgment, having heard all the information this evening and the debate.
Thank you. Councillor Williston.
Sorry, can I
Chair.
sorry, Councillor Dick, can I just clarify that was on the first item? The first item
Yes.
before, yeah.
Apologies, I should have asked you. I just presumed I knew which one, but obviously Sharon was absolutely certain. So thanks for reminding us, Sharon. Councillor Williston.
None, Chair.
Okay. Councillor.
None, Chair, none.
Councillor.
Yes, on the second item, the applicant and myself, by being met on the site visit, appear to volunteer for the same organisation, but we don't really know each other. But just so it's on Kennet Radio, just to be clear, both volunteer for Kennet Radio.
Well, Councillor Abbs, I think I know various different speakers tonight, but in a very loose way, and I would definitely not be making a formal, declaration that they're close to me at all. But all I would say is I think I'm probably the same as many other members. I've probably received various items, correspondence over the last week or two, which you could argue is some form of a declaration, but we definitely have had a certain amount of information fed to us on, definitely on one of the applications. You haven't?
As per the last time we met, I get nothing. I don't know what's happening, but
Oh, okay. Well, perhaps that's something we can take away outside
no,
this meeting.
I'm quite happy not to be lobbied. It's fine.
Okay, thank you very much. Okay, members, we now move on to the first item for the debate tonight, item 4 in brackets 1, and we're referring to the application 23/00815 FUL, land south of Sandhill, Hampstead Norris Road, Hermitage. Now, before we actually get into the speakers, it would be useful for me just to identify to people that are not necessarily conversant with the procedure we follow at this meeting, but I'm going to briefly explain the procedure. Officers will present the application to the committee, after which the following groups might wish to make representations for a maximum of 5 minutes each. Firstly, the parish or town council representatives, the objectors, the supporters, the applicant and or the agent and ward members. The committee members will then have the opportunity to ask questions of clarification of the speakers. Members will then have the opportunity to ask questions of the officers. The committee will then go into debate on that particular item before determining the application. I'm now going to formally invite Michael Butler to begin his presentation on this particular application. Over to you.
Chairman, point of information, we have a part 2 on this. I just wonder whether we are going to actually make a decision.
Councillor Williston, we only go into part 2 if there's any particular issue that you feel is appropriate that needs to be discussed. It's possibly not necessarily totally relevant to our determination in debate, but there might be something in clarification that you might wish to ask, which we might need to go into that part. But my understanding is it's very unlikely that we will need to go into part 2.
Thank you, Chair, for the clarification.
Thank you for making that comment, Councillor Williston, anyway. Okay, over to you, Michael.
Sorry, Chairman, may I just ask that the presentation be done in presentation mode, not in, I'm currently looking at speaker notes. Just need to switch the screens around. One you're looking at will be the presentation, the one we want, that's the one we want to see. Just switch your monitors around. If at all possible, please.
Sorry, apologies.
That's all right, I've just, my eyesight's not that good, so.
There you go. Thank you very much. So the application comes to committee because the officer recommendation is to approve this part retrospective application at Hermitage for the change of use of a former greenfield paddock to the formation of 5 gypsy traveller pitches, which, if permitted, will comprise 1 mobile home, 1 touring caravan and 1 utility building per pitch. The reason it's come to committee is because with the officer recommendation to approve, the council has received well in excess of 10 letters of objection. This is the red line site, is the application site for those of you who know it and those who attended the site visit on Monday. I'll quickly go through the slides and then I'll do the remainder of my presentation if that's useful. This is an updated site plan which has been on the public website for some time, indicating, you may not be able to see it, but there are 5 pitches evenly spaced through the site. Each pitch is approximately 0.1 hectare in extent. There's an internal access road on the western boundary. And for those of you who know it, there's a public footpath cycleway immediately to the east of the application site. This was the existing site pre-development. It is a greenfield site, and in planning terms, it does remain a greenfield site at present because there's no authorised use on the site. This is the block plan, slightly more clear as to where the development will proceed if it's permitted. General location plan, you're familiar with that. This is the landscaping strategy plan, which may be helpful. I don't know whether you can, no, you won't be able to possibly see the cursor. I'm not sure if it's going to work. But if the committee decide to grant permission tonight, one of the conditions on the agenda specifically notes 5 metre wide buffer zones for landscaping on the south and north and eastern perimeters of the application site to ameliorate any visual impact, but I'll speak to that in a minute. The only elevations we got are the proposed day rooms. For caravan sites such as this, we do not have elevations as they're not required in the planning legislation. This is a plan of the proposed footpath link, which I'll speak to later under the highway section. But it's important for those of you to know the site that where the existing access is, a proposed 1.5 metre width, although this says 1 metre, but it should read 1.5 metres, apologies for that, will be created on the site post permission. And hence to the photos, I'll quickly run through those before the main presentation for those who are not familiar with the site. This is a photo of where the footway will be constructed. This is a photo of the B4009 looking north from the, I believe it's Torcove's driveway, dwelling to the south. And these are photos of existing pitches and vans on the site. It's really for those of you who perhaps have not visited the site and been able to get onto the site. We were clearly there on Monday morning. So the sites are fairly spacious. There are a number of amenity blocks. There's quite a lot of domestic paraphernalia along the eastern boundary line. This is plot 1 to the south. Bin storage, the internal access road, which will be improved if the permission is granted. Plot 4 currently vacant, at least it was vacant when the photographs were taken, which were about over a week ago. This is the site screen to the west. That's the treed boundary adjacent to the B4009. These are various vehicles to the east. And this is a view of the whole site looking south. This is the view one would get from Sandhills from the north looking south. This is plot 2. This is the site access looking out westwards. And this is the site looking north towards Sandhills, the house to the north of the application site. This is plots 4 and 5. And this is a gas canister on the site, of which we have received some objections. As I mentioned, the site was greenfield. It's outside the defined settlement boundary of Hermitage. It is a greenfield site. I'll just come back to the location plan before I carry on with my presentation. The site has nil planning history. Just to confirm to the committee, because the site lies within the North Wessex Downs National Designated Landscape, which was the A&B, the planning authority is required to issue an environmental impact assessment screening opinion. And we did that recently, and that was a negative screen, i.e. the applicant is not required to submit an environmental statement in support of the application. There are no local financial matters to take into account in looking at this application, and that's in the section under financial considerations. In terms of the public sector equality duty, it's important for the committee to remember in determining this application that the Gypsy and Traveller community, as defined by the government legislation, do have protected characteristics as an ethnic minority, and therefore that is a relevant planning consideration in determining this application. In terms of the consultations received to the application, I'm sure you've all read the report, but there are very strong objections from Hermitage Parish Council for the reasons set out in the report. Hampstead Norris Parish Council also objects to the application. They're the adjacent parish to the north. However, all the internal statutory consultees, the highways officer, the ecologist, the tree officer, the environmental health officer, the planning policy officer, and the drainage officer, the latter subject to additional information, are not raising objections to this application, and they are recommending conditional permission if indeed that is what the committee decides to do. In terms of public representations, at the time of writing the report, the council had received 62 objections. To date, we have received 3 more. It's on the website. And so we have 65 objections in total. There are no letters in support of the application. The issues which are raised are set out on paragraph 5 on page 15 of the report. And I won't reiterate those now. I'm happy to answer any questions if necessary. The council over the last few months has been sent a range of letters by a group of concerned Hermitage residents. However, this was anonymous. So unfortunately, it's very difficult to know whether the letter in fact comes from one resident or 100 residents because it is anonymous. However, we are highlighting their concerns under the section just before planning policy. So the committee are aware of that. And indeed, those letters have been placed on the public website. In terms of planning policy, I won't go through any detail. I'm happy to answer any questions on that. Suffice it to say that under 7 appraisal, the West Berkshire Development Plan, this application does actually, in officer view, comply with policy ADPP1, which is the principal strategic planning policy in the West Berkshire core strategy, since it is a development adjacent to the defined settlement boundary, which does meet identified needs, i.e. the needs of the Gypsy and Traveller community. The other policy which the members need to take carefully into account is ADPP5, which relates to the AO&B, i.e. now the national landscape. You will need to take careful consideration of whether this development actually enhances the landscape or in fact harms the landscape. And I'll talk to that in more detail in a few minutes. The next principal policy is policy CS7, and that's in the West Berkshire core strategy. The report goes through in some detail as to why officers consider that in nearly every case, all of the criteria within CS7 are actually satisfied by this application, or if not satisfied, can be conditioned appropriately. And again, because of the length of the presentation, I won't go through those in any detail, but I'm happy to answer any questions. The same exactly applies to policy TS3, which is in the HSA DPD. That is the Gypsy and Traveller detailed criteria policy, and that is considered from 716 onwards in considerable detail. Turning to national planning policy, it's important to remember that the government specifically makes an exception to the development of Gypsy and Traveller accommodation in the open countryside where it is appropriate, i.e. it is a permissive policy. And this is set out in the DCLG publication Planning Policy for Traveller Sites dated December 2023. That is a formal annex to the NPPF of the same date, and therefore it is the principal government guidance relating to traveller sites, not only in West Berkshire, of course, but of course across the whole country. The detail of that is set out under national planning policy. It's also important for members to remember that policy DM20, I believe it is, of your own local plan review is an emerging policy which basically combines CS7 and TS3, and that is reviewed in paragraph 7.40. Turning next to local need and supply, this is a very significant part of the report in officers' view. Officers have given significant weight to the local need and supply for Gypsy and Traveller pitches in arriving at their favourable recommendation. Again, I'm happy to answer any questions, but in the short term, over the next 5 years, the council requires 1 additional pitch. But in the longer term, up to 2038, we require 18 pitches. And I should remind members that the council has not allocated any specific Gypsy and Traveller sites in its local plan review. And hence, perhaps not surprisingly, the council is seeing additional pressures across the district. Some of you may be aware, for example, the pressures the council is also already getting specifically at Brimpton Common from the Gypsy and Traveller community. In terms of landscape character, visual amenity in the national landscape, the applicant submitted a landscape and visual impact assessment. This was individually assessed by one of our consultants who has been highly critical of that visual impact assessment, and that assessment has been placed on the public website. Notwithstanding that, officers still consider that the site is not very well screened, but it is physically very well contained. As you see from the slide, we have the B4009 to the west, the TPO trees to the east, and residential development to the north and south. So in terms of the wider AO and B, we consider as officers that the wider impact, sorry, I should say AO and B, I should say NDL, is very constrained, and therefore on balance, I stress on balance, the visual impact is acceptable in the NDL. Turning to highway matters, the current access to the site is clearly unauthorised and is not a good access. If you elect to grant permission tonight, there are conditions which will improve the visibility space to the north and south, which is definitely required, and the construction of the new footway from the access to the south, linking into the existing access and footway adjacent to Tor Cove. The next issue is drainage. This again is a very important issue. This matter has not been resolved as yet to the satisfaction of officers, but we did not want to delay this application any further for obvious reasons, because it has been before the council for 18 months. And therefore, as I'm talking about drainage, I wanted to refer you to the update sheet to make clear that the revised recommendation of officers is still to approve the application, but the caveat is, and I'll read it in full for clarity, the Development Control Manager be authorised to grant conditional planning permission on the receipt only of satisfactory drainage details, which will include both surface water and foul drainage details, i.e. if you do resolve to grant permission tonight, no formal decision notice will go out until the drainage details have been satisfactorily resolved. The next principal issue to consider is noise contamination. The site lies approximately 120 metres to the south of the M4, which, as many of you will know, is elevated in this area. And therefore, there is the dissemination of noise, if I can put it that way. Mobile homes are clearly not dwellings, so they are more susceptible to noise pollution. The Environmental Health Officer has recommended a number of conditions, should permission be granted, in order to ameliorate that acoustic impact, which does involve acoustic streams to be erected to the north of each mobile home on the site. Clearly, they're not there at the moment. Following on from that, on the ecology of the site, the applicants, after some discussion, I have to say, eventually submitted a preliminary ecological appraisal, which the council ecologists have carefully assessed, and they are not objecting to the application. They are recommending conditional permission. Also, the council's tree officer is also recommending conditional permission, notwithstanding the tree preservation order to the east of the site. In terms of neighbouring amenity, and this is perhaps quite a difficult thing to say in making a recommendation to approve, but I'll say it as the case officer. We do not resile from the fact that if this permission is granted, there will inevitably be a degree of detrimental impact on the dwellings immediately to the south, which is Tall Cove, and to Sandhills to the north, because there will inevitably be increased noise and disturbance, and there will be a loss of outlook compared to the Greenfield site before. However, we think that amenity impact is relatively limited, and we've taken that into the balance in our recommendation to approve the application. But the council needs to be aware of that issue, and I'm sure those who attended the site visit would have noted that. In terms of community cohesion and fear of crime, it's not for officers to make any comments on community cohesion. That is a matter for the local community, but it is a material consideration which is stipulated in the PPTS, which I've mentioned. And you will be aware that there are now 65 objections to the occupants of the site, or the occupation of the site, not the occupants. In 7.78, we make the point as officers that the fear of crime is actually capable of being a material consideration, as was established by the courts. But we consider, for the reasons set out in the report, and this is a fine legal point, and I don't pretend to be a lawyer, that the judges in these various court cases have concluded that, having regard to the above legal authorities, it is considered that the fear of crime is not a material consideration in this instance, and we concur with that in arriving at our favourable recommendation to this particular application in this case. The committee, of course, may take a different view, but that is officers' recommendation. Last but not least, not quite last, that is of intentional unauthorised development. We have received many objections on this. It is absolutely clear, and the applicants, through their agents, have admitted this, This is intentional unauthorised developments. And that is a material consideration which you can take into account. However, it is not an offence in planning law to submit a retrospective application. Excuse me. And therefore, the planning committee is required to consider this application on its land use planning merits, notwithstanding the fact this is clearly at the moment unauthorised developments. Then there is a matter of precedent, which is not normally a planning matter. In this case, officers consider that precedent, whilst it's capable of being a material consideration, is not relevant in this application, because if it's approved, there is physically no possibility of any expansion of the site in this particular case. So before I come to the planning balance and conclusion, I just wanted to draw your attention again to the update sheet. If you approve the application, we're recommending that you add on 2 additional conditions. One is the removal of permitted development rights for fences and walls, because on open land, under the schedule, it is possible to erect fences up to 2 metres in high, which would contain the site, and we don't want that. So we recommend that you control that through this removal of the PD rights. And we are also, just for clarity, and this arose on the site visit, that the distance of any structures, hard standings on the pitches cannot be within 5 metres of the eastern boundary, because that will be the proposed landscape buffer strip. So moving finally on to the planning balance and consideration, conclusion rather. Officers, again, do not resile from the fact that if this is approved, there will undoubtedly be some harm to the local area in visual terms. However, it will mean that the council can provide an additional 5 gypsy and traveller pitches through the plan period up to 2038, which will definitely be beneficial in providing the gypsy and traveller community with appropriate accommodation in the district, and that's set out in paragraph 8.4. So we are recommending conditional permission, Chairman. Thank you.
Thank you, Michael. I'll move my screen away. The Pauls, any comments at all from highways or drainage, environmental health at all that you wish, or you specifically here? Oh, you've got some comments, Paul.
I can make some comments if you wish, Chairman.
Well, if you feel it's appropriate at this stage before members ask you questions at a later stage, go ahead.
Yeah. Thank you, Chairman. There is a small section on highway matters on page 24 of the main report. And I would just like to mention a few matters regarding the access and potential traffic movements. As mentioned by my colleague, Mr. Butler, the access is unauthorised. But there is a condition applied where details would be submitted of it, including the surfacing. And we are satisfied that there is adequate width for the expected vehicles to be able to manoeuvre in and out of the site. The applicants commissioned some speed surveys, which have been used to calculate the required sight lines for the access. The sight lines, as I'm sure many have noted, are not achieved at this stage, but they are achievable because they are within land that is either controlled by the local highway authority or by the applicant, and your highway officers are satisfied that they are achievable, and there is a condition included in the report to ensure the provision of the sight line. We also considered the provision for pedestrian access, and within the submissions there is a provision of a 1.5 metre wide footway coming from the site and connecting to existing footways from the south, and this would be secured by condition as well and provided by appropriate legal agreements. Traffic levels, but normally with these sites, when the families arrive, they're normally there for quite some period of time, for weeks or even months. So therefore, any caravan movements are few and very infrequent. But the families themselves, when they live there, will have day-to-day traffic movements, which we would expect to be somewhere around 3 vehicles in and out per day per pitch. So altogether up to 15 vehicle movements in and out per day, which is a very small number, which should not cause any traffic matters. And therefore, subject to the conditions applied within your committee report, subject to those items being provided, your highway officers have no objection to the proposal.
Okay, thank you very much. No members. Before we move on to the speakers on this application, we have had a request. Unfortunately, it missed the deadline.
Is there any presentation on the SUDs, please? Because that's quite important on this. Mr. Backus.
I did look to see, and he didn't put his hand up. But if
I
he
didn't put my hand up, but I can just clarify matters if that would help members.
Paul, go ahead.
I think it would be helpful. So the applicant is seeking to control runoff on this site via discharging water to ground using permeable paving systems. One of the dependencies of permeable paving systems is having good ground conditions. So the applicant has, after we've requested it, provided ground investigation results. Upon review, it appeared that there were errors within the ground investigation results and the calculations that had been carried out. Subsequently, the drainage strategy, which was based on those calculations and that data, is flawed. So we have requested that the applicant try to correct that information and verify that the solutions they have put forward are acceptable. That's the main missing information from this application, which Michael has mentioned in his presentation.
As you've just clarified a few points, Paul, I just looked to the environmental health officer. Was there anything that you felt at this stage you should actually point out at all?
No, Chairman, nothing to add.
Okay, thank you. Right, members, continuing on from what I was about to commence talking about a minute or so ago, before we obviously move into the speaker's rights, we did get a belated request from Martin Powers, the member of Hermitage Residents Group, who I gather had problems regarding meeting the 1600 hours deadline yesterday. And it's really up to members to consider whether they feel appropriate that members of this group that would obviously be speaking as an objector would be invited to actually speak. We obviously need to suspend standing orders, but it's up to you members if you feel it's appropriate for Martin Powers to make a presentation. That's the way that we're going to have to proceed. So members, what is your wish? Councillor Amasraj.
Thank you, Chairman. Just a question. I also noticed that there is no speakers for the application on agent. So is it intentional or has just been missed out because of the deadline?
My understanding is there was an illness in the family and Mr. Powers had to attend something else at the last minute.
Sorry, Chairman, I was asking, I understand the objector's position here, but I also noticed in the speaker list, there is no speakers for the applicant and agent or slash agent here.
Okay, Councillor Amasraj, I think that has been noted by other members as well and been pointed out. They were invited and I can assure you that the appropriate planning officer made various attempts to speak to applicant, agent and any other person that wished to come and speak presenting this particular case, and my understanding is they were unable to actually get some response of a positive nature. Now, I'm going to refer it to. Can you give further information?
It's not so much further information, it's just to confirm that the sheet is correct and that the applicant and the agent aren't speaking.
Okay, so if they're not available at that time, can we understand if they are willing to
So-
speak?
Well,
So-
they don't have to speak. So if they've opted not to speak, that is their right. And I
Exactly,
don't,
that's
I
my-
don't think we should delve.
No,
into the reasons why.
that is where exactly I'm coming from.
It-
So they're not willing to speak
Well,
because the reason.
they feel they don't need to speak, I think,
Okay.
is how we put it, is probably the appropriate.
The reason I was asking that question was that if we are not hearing from the applicant, just hearing from the objector, in this case, they missed the deadline, we wouldn't be hearing both sides. So that's why I'm trying to make sure that before we consider that.
I think
there
Mr.
is
Butler
equal
might have,
opportunity.
I think
Yeah.
Mr. Butler might have more information.
I think I'm going to call Mr. Butler on this case.
Yeah.
Not normally the procedure, but I think it's appropriate.
Don't normally comment on procedural issues, but hopefully it will help the committee as the case officer in order to give hopefully as a rounded a debate as possible for obvious reasons. I did actively contact by email the applicant's agent on Monday to remind them of the deadline and to say, would they be coming twice? They said, no, they wouldn't. It's their choice. They're not obliged to. And secondly, I did actually email one of the applicants as well to say, in the light of their agent not wishing to speak, would they wish to speak in favour of the application? And they declined as well. So that has been covered carefully by the planning authority.
I
you,
hope
Cam.
that answers the point, and I think you remember correctly, it's happened on occasions in the past. We've been in a similar position. Okay, thank you. Right, councillor, sorry.
I think, but I just want to be clear, they don't have to speak and they might feel that the planning officer has put the information they would have said in the report. So I don't want people to think that they're somehow, that there's something missed because they're not speaking.
Yeah, I would second that as well. The applicant and the agent don't have to speak, because if they feel in this case that Ms. Sama has said that if all the information in the committee report is what they would have wanted to put forward anyway, then,
Okay,
they don't have to speak.
moving on, councillor Abbs.
Yeah, I'm personally, I'm very happy to hear from the person who would like to speak, but I just want to double check that they do realise it's part of the 5 minutes available to objectors, not a separate slot.
Although the individual concerned I mentioned is a residents group, it is the objector. So you are absolutely spot on there.
Okay,
So,
thanks.
yeah, and you're making it quite clear for the audience. Right, councillor Hooker.
Thank you, Chairman. I'm quite happy for this gentleman to speak. The thing I bring to the committee is this is becoming more regular, and this committee is accommodating latecomers, and it somewhat negates our 4 o'clock day before rule. If it's going to happen on a regular basis, it might just sort of weaken that argument. We just have to be a bit careful. We're seeing quite a few. I know this is a good, reasonable reason why on this occasion, but I just bring it to the attention. If you could recall, we're getting more and more latecomers to speak.
And from the chair, vice chairman, I think it was the meeting which you weren't present because unfortunately you had other domestic commitments. I made exactly the same statement, that I felt that I gave the benefit of the doubt to individual. I won't go into which particular application it was or which parish council, but I said I felt that I did not want to be in the same position again. Well, I am in the same position again. And I think you're absolutely spot on. I think we need to be quite precise on this because there will be individuals attempting to try and override the 1600-hour Tuesday afternoons cut-off point for various reasons. And I think we need to probably be very specific. So I think that probably it's a if this is accepted tonight, it's a yellow light, I think. Right, members, we've had a proposal. Are we having a seconder? Yes, councillor Williston. All those in favour? Okay, Right, for members of the public, we will now go through the process. So it will be the Parish Council that will get the opportunity to speak first. And then because we've obviously going to be slightly different in the procedures, because you've heard that the applicant won't be speaking, the objector, in this case, Martin Powers, will be the second speaker. So if I call upon Ruth Cottenham on behalf of Hermitage Parish Council. Ruth, if you can stand by the lectern. You've got 5 minutes and we will notify you after 4 minutes that you're in the last minute. So soon as you're ready. Okay.
Thank you.
The clock starts soon as you're ready.
Thank you.
Okay.
Good evening, everybody. Thank you for giving us the parish the opportunity of speaking. Elected members are perfectly entitled to make their own judgment and refuse planning consent where the assessment made by their officers is wrong. That is what you should do tonight. The council's own independent landscape advisor finds that the scheme fails to conserve and enhance the scenic beauty of the national landscape. She also finds, which tonight's report does not mention, that the scheme would be to the detriment of the national landscape. In other words, that it would actively harm the area. Her report also says the development proposals have not met any of the guidance as set out within the North Wessex Downs Management Plan. She advises you that the applicant's livia was flawed. The proposal harms the visual character of the area. Even well-managed caravans and static homes will be visible in the short to medium term. Landscape buffers and screening will be ineffective, even if they are cared for properly. You are invited to disregard your own experts' advice. You would be in breach of your legal responsibilities if you do so. Section 245 of the Levelling Up and Regeneration Act 2023 now requires that all your decisions seek to further the purpose of conserving and enhancing the natural beauty of the national landscape. You cannot approve an application without knowing how foul waste is to be managed. A cesspool is completely unacceptable on a site where people may have no knowledge of the arrangements for it to be emptied and serviced. Their health will be at risk if the system backs up, and contamination will be a real possibility. Connection to main drainage system may be possible, but that does not mean that it will take place. The impact on ecosystems and legally protected wildlife is also negative and is only considered acceptable with significant mitigation. Are you sure that the measures being conditioned, such as the installation of dormouse boxes and bat-sensitive lighting, will actually be carried out and, more importantly, maintained? Do you even know who will be responsible for doing so? If not, how can you risk the harm to protected ecosystems by granting consent? The advice you are given in the officer's report is wrong on landscape grounds, incomplete on other matters, and relies on mitigation, which in all likelihood will not be enforceable. The assessment of the planning balance is incorrect. It is difficult to find sites for gypsy and traveller pitches, and there is considerable pressure for them to be approved. But this proposal is unquestionably in conflict with important policies in the national landscape and your overriding duty to protect biodiversity and the national landscape. A planning committee is fully entitled to exercise its own judgment and disagree with its officers. There is good reason to do so, and there are very good reasons in this case. Please refuse this application. And just one more thing, I asked, there are 18 members of that so-called anonymous group. Thank you.
Thank you. If you can just wait there, Ruth, I
Yeah.
expect there's some questions from members. Okay. Right, councillor Hooker.
Thank you, councillor Cottingham, and thank you for coming along and representing the Parish Council this evening. So often applications come with objections from the Parish Council, but they don't come and make their case. So I certainly appreciate your presentation this evening. Has there been any dialogue between your Parish Council, the applicant, the residents already there, because they've been there a considerable time, or have they come to any of your Parish Council meetings to make their case?
We had 18 months ago, we hired the school hall, which was full. So many residents came, including the owner of the site and people that we believe are residents of the site. So they did come. And I'm pretty sure that one other councillor has actually been in touch with the residents.
Thank you.
Any other questions for Ruth Cottenham? No? Okay, Ruth, thank you very much.
Thank you. I'm sure it probably doesn't matter.
Okay, I now call upon Martin Powers. And again, you've got 5 minutes and we will notify you after 4 minutes.
Good evening, members of the Planning Committee, and thank you, Chair, for the opportunity to speak. Just a few words. For the record, I live in the northern end of the village of Hermitage, and I would like to say absolutely that I've got nothing against travellers per se, or any individual currently on the site. This is about planning, not about personality or lifestyle. I also speak on behalf of members of the Hermitage Planning Group. For the record, this is an informal collection of local households who've made various representations to the planning officers over several months. May I remind members that this matter started when the applicant arrived in the middle of the night under cover of darkness and without any prior warning. Numerous large loads of hardcore from an unknown source was dumped on the land and levelled by a mechanical digger by darkness. By daylight, the site was occupied. The application before you was submitted on the 6th of April 2023, 18 months ago. The statutory date for the settlement of the application should have been the 1st of June. And I'm not sure that other applicants would have been given the same luxury of time. The recommendation of this is acknowledged to be the highly contentious planning application, and the delay in preparing the report is justified at point 786, having to make numerous requests for the applicant to provide additional information. The recommendation to approve before you is argued by a 22-page report. In my view, this draws highly selective conclusions based on a repeated use of the words balance or balanced and weight or weighting. The report has established that this is a case of intentional unauthorized development. At 7.82 in the report, we're reminded that the Secretary of State has set out in a written statement that this is a material planning consideration in determining planning applications to create a level playing field and not to undermine public confidence in the planning system. Mr. Butler has already referred to that. At 7.83, the report goes into a rather diverse explanation as to why this matter carries limited weight and why the views of 65 objectors and both affected parish councils can be ignored. The body of the report is contained in section 7, marked appraisal. There are several instances where the matters contained in this section do not appear to reflect the content of the reports lodged on the planning portal. This should be a matter of omission, maybe, or a selective interpretation of the facts. For example, under 7.3, the claim is made that the proposal will address an an identified need for additional gypsy and traveller pitches within the district. However, reference is also made to a change in the definition, now resulting in a shortfall of 1 pitch in the next 5-year term. And this is despite the statement by Councillor Gaines at the West Berkshire Community Forum on Planning on the 10th of September this year, that West Berks Council was meeting the 5-year supply at present, quote. Under 7.8, the report correctly records the requirement that great weight should be attached to the conservation of the natural
1 minute
quality
left.
and beauty of the national landscape. Yet officers seek to advance an argument that because of the proximity to the M4 and the built-up area of Hermitage, this is to be discounted. There are also another of important issues which remain to be resolved. Some of them have been touched on already. I would draw your attention to issues relating to highways where splays require significant removal of hedgerow, drainage concerns raised by the drainage officer, which we've already heard about. The drainage officer's report requested 13 specific conditions, but nothing appears to have been carried forward into the conditions at section 9. Other issues include acoustic noise barriers and provision of ventilation. It occurs to me that in view of the applicant's apparent reluctance...
Can you conclude, please? You've got a few seconds
One
left.
moment. In view of the applicant's apparent reluctance to provide timely and proper information in support of the application, can I ask, do you feel it likely that all the conditions and restrictions attached to this recommendation to approve will ever be complied with? And if they're not, who will be responsible for the enforcement?
Thank you. Question, members? No, we don't seem to have got any questions. Right, you can return back to the your seat, and we now resume. We can suspend we're back to standing orders. Can I have a proposal to return to standing orders? Seconded. All those in favour? Right, okay. In view of being no supporters, no applicant, no agent, we now move on to the ward members. And I believe Heather Codlin is going to speak. Is that correct, Ellen? Yes. Okay. And of course, you're subject to 5 minutes as well. So as soon as you begin, we will get the stop clock.
Thank you, Chairman. So firstly, as a councillor for West Berkshire Council and ward member that covers the parish of Hermitage, I'm here to reflect the views of the village residents, but also as an elected member, I will use my own judgment and offer my own opinion. I'm aware that there is a lot of strong feeling against this development by many residents in Hermitage. This piece of greenfield land has been occupied for some time now, waiting for determination of the planning application. Residents are upset that this has not been dealt with more quickly, and a great deal of latitude has been afforded the applicants to provide the correct information. With the time elapsed and the continuing presence on site, local residents feel this is a done deal. Like many members of this committee, unauthorised development leading to retrospective applications are never good, and this is often perceived as undermining the authority of the local council. I believe it is West Berkshire Council's responsibility to provide sufficient sites for gypsies and travellers across the area, but it is apparent that this council has historically failed in this and sufficient sites have not been identified. Situations like this occur and people then essentially take matters into their own hands. I accept that development plan policies allow a permissive approach to gypsy and traveller site development, which is different from our general residential development, and I recognise the allowance for protected characteristics. With regard to the site itself, I believe if this had been a typical application for a house, it would have been refused, especially as there is a presumption against development outside of settlement boundaries. The site has a number of reasons for refusing this application, including, but not limited to, the access. It's poor, the visibility displays are poor, and so for both vehicles and pedestrians. The entrance is very close to where the speed limit change is, with the traffic speeding up and slowing down at this point. This former greenfield site is not only outside the settlement boundary, but is located in the North Wessex Downs National Landscape, formerly the AONB, and it's an unacceptable development on there. The impact on wildlife, both flora and fauna, should not be dismissed, including possible damage to the protected trees on the neighbouring site, damage to the hedgerows that have already been removed, reducing the habitat for dormice, bats and many other creatures, large and small. The light pollution from the site will also affect these same creatures. The site is visible from both the road and Ealing Way footpath. The proximity to the M4 motorway and the noise levels that these residents will be subject to is deemed unacceptable, as caravans have little insulation to protect them. The impact on neighbours and the perceived impact should not be dismissed either, particularly to those immediate neighbours. Though this site sits within flood zone 1 and not subject to a high risk of flooding, the runoff from the site is perceived as an issue. This is a clay land site, and so contamination to local watercourses is distinctly possible. It has, over the past year and a half, taken a lot of work to get reports and information from the applicant. Should this be approved, how will this council ensure the works are done prior to the further occupation? I have spent, as many others have, a lot of time over the last year and a half reading reports and correspondence, both directly
1 minute to go.
Thank you. And directly to me and on the planning website. In my view, at this point, I support the residents who live locally and are upset by this development. I therefore request this committee make a sensible, pragmatic decision and refuse this application.
Thank you, Heather. Members, questions to Councillor Codlin? Okay, you've got off lightly. Thank you very much. Oh, sorry, sorry, apologies, Councillor. Okay.
Thanks, Councillor. A question similar to that to the Parish Council. Have you had any meetings with the applicant or the resident? Have you been on the site?
I haven't been on the site. I've walked along the side of the road. I've more spoken with local residents there who have come to me with complaints. No, I haven't actually spoken, apart from during the meeting that Councillor Cottingham mentioned.
Okay, thank you.
Thank you. Okay, right. Councillor Drummond.
Yes, thank you. I've heard twice this evening, a great deal of latitude has been given to this application. Have you got any proof of that?
Well, the length of time it's taken to approve, to even get to this stage, and the request for reports that don't come forward. Normally, we would have refused that and say, well, you're not providing the information. You know, why are we bothering?
Okay, thank you.
Okay. I think that's the end of it. Yeah, thank you, Councillor Colton. Okay. Well, members, we now come to the point where you've obviously got the opportunity to question the officers, and I think it'd be appropriate, bearing in mind that we've got Russell Davison, Paul Backus, Paul Goddard and Michael Butt at present. Perhaps you'd like to indicate which officer you're going to direct your question to. Right, Adrian Abbs.
Thank you. I guess the first one will be to Mr. Butler. Could you tell me whether or not, obviously we've talked about the 1 metre footpath that's going to be created, but of course there is actually a footpath that runs all the way to the east on this site. No, there isn't a footpath there. I thought we walked up it when we did the site visit. It's a what, sorry? It goes all the way past the site.
Do you want me to answer that?
To the north, south, east, to the east of the site. East. What did I say? Did I say west? I'm sure I said east. So
it's on the west side.
I know, I realise this. That's my question is, have we not explored access? That's the wider question.
Do you want me to answer the question?
Yes, please.
Yeah. So, well, I don't know if I bring the location plan back up, but there's a existing footway immediately to the frontage of Tor Cove which is the dwelling immediately to the south. And then there is no footway for at least 10 to 15 metres to the access point. So if this is approved through a Section 278 agreement with the Highway Authority and at the cost of the applicant, a new 1.5 metre footway would be constructed from the south of the access, linking into the current footpath at Torcove.
Okay, can I, that really wasn't my question.
Apologies.
There's a footpath that exists to the east of the site that goes all the way up and down. It's the old railway line that goes miles and miles and miles.
Okay.
And my question was no exploration done by the applicant with the parish council, because the parish council own that site, in terms of making an access? So we wouldn't need to then have 1.5 meters wide on the roadside. So
first of all, that land would be outside the red line and therefore the control of the applicant, and it would involve third-party land, so they would have to get agreement with the parish council, I believe, who own that. Secondly, there could be harm, in fact, there would be harm potentially to the TPO trees, which are there. Thirdly, as you recall from the site visit, there's a considerable gradient difference. So the construction of an access there would be quite difficult and costly. Of course, it would be possible. The access on the highway is far more logical and straightforward in officer's view.
okay, thank you very much.
You okay?
I have another question later on, but
Okay, right. Yeah, I've got three other members that wish to ask questions at the moment, and I think Councillor Billy Drummond was the first of the three.
Yeah, I would like to ask Mr. Butler the same question. A great deal of latitude has been given twice to this application tonight. Could you give us some light on that?
First of all, I'll say that the process and administration of a planning application has no bearing whatsoever on the committee's determination of the land use planning merits of this application. Secondly, I will say, because it has been raised by objectors, which is unfortunate, that due to workload allocations, I was not the original case officer. I am obviously the case officer now. That in itself has caused procedural delays. Thirdly, I don't like to use the word admit, but I agree that the applicant's agent has been very slow in providing the necessary information. And it is possible in other applications it could have been refused at an earlier stage. However, the applicant was agreeable to extensions of time. And given the fact that we do have a recognised shortfall of gypsy and traveller pitches across this district, as an officer employed by the local planning authority, from a professional point of view, there's an onus on myself as case officer to see if that shortfall can be addressed. And in finally arriving at a favourable recommendation to this application, that is why this application has taken considerable time. But I do stress, and I don't take it as a criticism at all, but I do stress that process and administrative procedures have no bearing at all on the land use planning merits of this case.
Thank you.
Okay, right, Councillor Pordick.
Thank you, Chairman. And I just should say that I'm also the ward member for this area, but I waived my right to speak because I want to be involved in the debate and keep a clear head. Two-part question. Could you firstly, Mr. Butler, please remind us of what that shortfall actually is today, please? And secondly, 7.36 and 7.82 are interesting paragraphs in your report. I'd just like you to just talk us over them, please. What was the number?
7.4. The shortfall of pitches over the next 5 years is 1. The shortfall to 2038 is 18.
Yeah, okay, so 7.36.
Yes, clearly this application site does have a visual impact on the NDL, and the committee will need to take this into account in balancing their decision. And what was the other reference?
Anything more to say about that?
Yeah. And as I said on the site visit, when purpose of the site visit is to point out the physical aspects of the site, officers do not resile from the fact that if this application is approved, there will be visual harm. The impact of the site is not neutral. There will be harm, and we don't resile from that. However, in arriving at the favourable recommendation, officers take a balanced view. And given the weight we attach to the need for additional gypsy and traveller pitches, and the fact, and I didn't mention it in my presentation, but it's in the report, this does lie in a relatively highly sustainable location with a lot of local facilities in the village of Hermitage. Those matters, in our view, weigh heavily in favour of approving the application, notwithstanding the visual harm.
Thank you. And the other one was 7.82.
Right.
And I'll give you a clue. There's a mention of public confidence.
Yeah, that's absolutely correct. And in fact, I have the report in front of me, updated the 6th of February 2019 on that very issue, published by the government, which is a consultation outcome for the powers of dealing with unauthorised developments and encampments of the gypsy and traveller community. And one of the points made in that later written statement is that the government is keen that public confidence in the planning system is not undermined by unauthorised developments, retrospective applications and so on. So that is a material factor which the committee can take into account. However, that does not change our recommendation to you to approve the application.
Thank you, Chairman.
Okay, right, Councillor Anthony Amatharaj, I think, was next, and then Councillor Wollaston.
You can't see with your screen up. You push your screen down, it should go down. Move it away.
Okay, I was reminded by the legal officer on the numbered name, so sorry about that if I've missed you off the list, but I've got you on the list now, Councillor.
Thank you, Chairman. I have two questions to the case officer, Mr. Butler. Number one is a number of speakers from Parish Council and the objectors have mentioned that if not for the travellers, this application from the travellers accommodation, this application would have been rejected because it's in the greenfield site and a number of objections or concerns from our own officers, particularly the drainage officer. I quote mentioning this, the drainage plan has got errors and flaws. So my question is, Mr. Butler, do you agree with that statement?
Sorry, I didn't get the question. Agree with which statement?
The question is, do you agree that their objections or their statements that if not for a traveller's application, if anyone else would have a normal application at the greenfield site with this number of concerns from our own officers, this would have been straight away rejected, isn't it?
That's a good question. I'm glad you answered it, asked it rather. Yes, gypsy and travel accommodation does have specific permissive policies for development in the countryside. If this site had come forward for a normal market housing scheme, officers would have automatically rejected the application unless it had been a brownfield site or an allocated site or a rural exception site for 100% affordable housing, which of course, well, those are the exceptions. So yes, we would have rejected it. Yes, we would.
Okay, thank you, Mr. Butler. That's clear. One more just quick question, Mr. Chairman. You mentioned in your early report that this site is illegal, unauthorized. So can I ask, is there any enforcement action is in place, and what's the status of that enforcement action?
I may need to refer to my legal colleague Sharon, but at the moment there is an injunction on the site, which was placed on the site early last year, I believe. That still remains on the site. If permission is granted, the injunction would be removed, obviously. If permission is not granted and the application is refused tonight, and no appeal is made by the applicants, we would certainly, it's not my decision, but I believe it would certainly be expedient to take enforcement action for obvious reasons. However, I will say that if an appeal is made, we will not take enforcement action, because at the end of the day, an appeal, obviously without prejudice, may be allowed on the site.
Thank you. Okay, right. I allows you to two questions, and I know Councillor Abs wants to come back, so I'm going to take Councillor Abs in a few minutes. Councillor Wollaston.
Thank you, Chair. I just want to explore the whole question of the need for parallel sites. In 7.4.3, you show Four Houses Corner of Pebworth as only one site, when in fact it's 17. Please.
Yeah, fortunately, I was the case officer for Four Houses Corner, so I can answer that. It is one site, but it's 17 pitches. Yeah.
But we need, can I, sorry,
I mean?
I'm being thick here.
Right.
We need 30 until 2038. And if you accept the fact that Four Houses Corner is 17 rather than one, we're pretty damn
right.
well there.
It's a very good question, but I can answer it. Four Houses Corner was already taken into account because it had an extant permission. It was an authorised site, 16. The application of Four Houses Corner was simply not for a change of use, but for operational development on an existing site, which created one additional pitch.
So you're saying, in effect, that up until March 2038, we need 46 pitches?
No.
That sounds an awful lot.
No. If you look at table 7.3, and I'm assured by my policy colleagues who are experts in this matter, the council requires a net increase of 18 pitches, okay? Up to 2038. A net increase over and above what we've got at the moment.
It's only one in the next 5 years, is that right?
That's correct.
And we're providing 5 here.
Yeah. But of course, that 5 would go towards the overall requirement. So if it's permitted tonight, the authority would only require over the remaining plan period an additional 13 pitches, 1-3.
Chairman, can I permit one other quick question on the drainage side of it?
Okay.
It seems, from what I can see, that drainage has not really been addressed at all. What is the solution?
It's been partially addressed by the suggestion of the use of permeable paving. They have tried to carry out ground investigation tests, as I've mentioned in my earlier statement. The testing had flaws. There were the results, the calculations weren't correct. What I've requested is either further testing information and verification of the results in the tests which were carried out previously. I need to get assurances that the solution which they're going to put forward is based on the correct data. So we need to make sure that the results from the ground investigations are accurate.
Sorry, Jim, does that include foul sewage or not?
No, that's not related to the foul sewage. This is relating to the surface water drainage and the permeable paving solution. The foul is being dealt with by a cesspit. So there is a plan to connect all the plots to a drainage system, a foul drainage system, which discharges into a cesspit. Whilst the cesspit is the least desirable solution for a foul system, they have followed the right process in the building regulations to determine that that's the only course, the only way which they can dispose of foul effluent on this site.
Thank you. Thank you, Chairman.
No, Vice Chairman.
Thank you. Mr. Butler again. Mr. Butler, did you say in your presentation there was no provision in the local plan for these sites going forward?
That's correct, Chairman. There is no allocated site.
Okay, thank
within
you.
the local
I thought I heard you say that. The next part of that question, who is actually responsible for finding and providing those sites? Does it come through the call for sites, or what is the responsibility of the council for providing these sites, as in Four Houses Corner, etc.? Could you just, for the committee's information and those attending tonight?
I'm not a policy officer, but my understanding is that as a precursor to the local plan review, there was a call for sites, as is done for any sites, housing, industrial. There was a call for sites for gypsy and travel accommodation, and only one pitch was promoted, clearly not sufficient. The council, of course, as the planning authority, could have elected to allocate and designate sites across the district. That wasn't done. That is, I stress, a council decision, not an officer decision. And therefore, putting it bluntly, with applications like this, officers are required to take into account the shortfall. And that's what we've done in this report.
Mr. Butler, that is very helpful. Thank you.
I think you said you had another question. Yeah.
The other question, I think, was following on from Mr. Backus, and it does say in the 7.71 here with regards to sewage. It might be the environmental officer actually who needs to actually answer this. It says, it is noted that to the south of the site lies a mains foul drainage outlet serving the existing dwellings to the south. If the application is approved, the applicants would be in a position. It doesn't say they must, but equally, I think we heard on the site meeting the fact that the distance is more than 30 metres, although they would be in a position, it wouldn't be our planners' position to impose on them that they do connect to that sewer, and therefore, it'll come out in the debate, I'm sure, we go for the worst situation of storage tanks and emptying of tanks and what have you. I just wonder if you could clarify that is the state.
Yeah, I can clarify. As you rightly identified there, because the sewage system, the Thames Water public foul sewer system is beyond 30 metres from the site, there isn't a requirement for the applicant to have to connect to it. That's why, as I mentioned to Mr. Williston, to Councillor Williston, they have followed the right process with the building regulations. They are in accordance with it. They can't use just to be clear, they also can't use a septic tank drainage flowing into a drainage field because of the extensive use of permeable paving throughout the site and the need to keep a clearance between the plots and a drainage field solution.
Have we exhausted all the questions? Right, no, because I was going to say Councillor Abs wants to come back, but I think you said you had more than one question. So, well, no, because I missed you out before, so it's only fair you ought to.
Thank you.
Have your say.
This will come in debate as well, I'm sure. When I looked at the plan, I thought, yeah, this is quite good. With regard to layout. When we go on the site, we then get talking about a 5 metre buffer on the north-south, every boundary apart from the west, which is the road. Now, my thoughts are both with the view from the railway footpath, the view from Torco. 5 metres when we stepped it out wasn't very much, and it's not very far from the boundary. I'll come back now to when I looked at the layout of the site. It does show these caravans in the middle of the site. Now, this has, I think, and I'd look at an answer on this, several implications. One is, if I put a house for planning and I stick it in the middle of my plot and I build it 5 metres away from the boundary of a neighbour, I wouldn't get away with it. So this application has come in showing these vans in the middle of the field. Now, I can see the advantage of that. One, a hard standing presumably put the van on. Two, we then got the maximum distance from the boundary. And three, coming back to the sewage, however it's going to be discharged, there's going to be some sort of pipe which needs to be close to the van. Can I have some idea as to why we're talking about 5 metre boundaries when we're actually showing these vans in the middle of the site and to the north?
Sorry, I don't really understand the question. Basically,
I do ask quite difficult questions, I appreciate.
it's not necessarily a difficult one. I'm not sure if I understand it because
let me try and make it clearer.
Yeah.
We've stated in the condition there that it's going to be 5 metres away from the boundary.
yeah,
We paced out 5 metres. It's no distance at all. We'll still see the caravans, as it were, from the railway line. The plan clearly shows the caravans in the middle of the plot on the north side. Why are we saying they shouldn't be fixed in the middle when the minimum amount of effect on all the boundaries? That's what I'm saying. If I was putting a house there, I'd have to put the house where it showed it on the site plan.
yeah, I can answer that quite easily, actually. The application is for the change of use of the land. It's not for operational development per se. So unlike the construction of dwellings where plans, the siting has to be at a precise point and approved plans, the plans on the block plan is indicative only. And if permission is granted tonight, on the pitches shown, that will allow the use of that land for the stationing of 1 day room, 1 touring caravan and 1 mobile home. By definition, those units, if I can put it that way, can move around as necessary with parking and so on through the lifetime of the permission within that plot. So it's for 5 pitches. I possibly haven't explained it very well, but it is a change of use of the land. The siting of a mobile home is the use of the land, it's not operational development.
Chairman, I appreciate that, but we've got a static tank of which you've got to get your sewage into if it's not going to go into the sewer.
Sorry, I can't.
Michael, I think I'm going to ask Deborah to answer that point.
Thank you, Chair. I think in this situation, if members were minded to approve, whilst what Michael's saying is correct, we can stipulate a more significant distance to the boundary of, when I'm looking at the plans now, the buffer's 5 metres, the mobile home at the moment is about another 5 metres, so we could specify 10 metres from the boundary. So it knows no structure to be within 10 metres of that eastern boundary, and I would be.
That's where I was going, but I didn't want to, I thought that would come out in the debate, but that's what I was looking at. Thank you.
Right.
Okay, right. Councillor Abs, you wanted to come back on the point, did you?
Well, several.
Or more than one
Several,
point.
unfortunately. First one for Mr. Goddard, I think. Splays, love them. How much of the splay is going to remove in terms of the hedgerows? How much hedgerow are we losing to accommodate the splays? Is it you or is it the ecology officer?
Well, that would be, I can tell you how much the display needs to be. Speeds are recorded with an 85th percentile of 37.6 miles per hour, which requires, under the design manual for roads and bridges, 100 metres.
100 metres?
100 metres to the north. Now, obviously, that sight line.
100 metres?
Yes.
Visibility, so the whole hedge?
So if you are stood 2.4 metres back within the site access at a distance of 2.4 metres from the edge of the carriageway, from that point, 100 metres until it reaches the edge of the carriageway.
Wow. Sorry, didn't need to use an appropriate word. Wow, but wow. Legal question next, please. We saw slides that showed several pitches empty. We went on site, all pitches were full. If there's an injunction in place, what is it injunctioning against? What's it stopping?
So the injunction was from the point that it was served. So it was what was on site at the point that the injunction was served. So if pitches were occupied when the injunction was served, then they can remain on site.
Yeah.
And so I don't know if that's sort of.
Well, not so you're basically saying if there were 7 caravans there, for instance.
Yeah, so
they
if
could still
they
be
had
there.
moved on prior
Okay,
to
so clearly
the
that-
injunction
clearly
being
that's the-
served.
Clearly, that's the case.
Yes,
because
that was
we
the
have a-
case.
Yep. So the injunction should have stopped these extra caravans coming on site then. Is that correct?
Yeah, so if there are extra caravans that have been brought on after the injunction was served, then that is in breach of the injunction.
So what action was taken?
That would be a question for planning because it's not
Planning.
it's not something it's not something that I would be able to do without instructions from planning colleagues. I don't
Okay.
personally monitor the site myself. That's a planning function.
But we're continuing to see the lack of adherence to the kind of the injunction rules we were given.
I haven't been on site.
Yeah,
so I'm not
that's that's just something I'll go into my balance of waiting when I make a decision in a minute.
I think if I could just add something there, the what members need to be mindful of is the application in front of them and what's being proposed as part of this planning application rather than the unauthorised development that's taken place on site.
Well, yes, I totally concur with that, except for 7.82, wasn't it? Intentional authorised development and continued intentional breaking of, injunctions and so on. So it's a material consideration that I can take into account according to that.
Yes, it is a material consideration you can take into account as
So
the
will.
committee report has set out.
And the final one was, we've just heard this has been going on for 18 months and the local plan started a little bit before that. I can't remember when it got to certain sections, but certainly so I'd be interested to know or get confirmation for the officers that the applicant, the owner of the land, who's now doing retrospective, did have the opportunity to bring this land forward for consideration during that process, correct?
Yes, that's correct.
Okay. That's me done. Thank you.
Councillor.
I think just to be support Mr. Butler, we went to the site and I think he was on that site the week before and those 2 additional vans had turned up since his previous visit. So with regards to giving instruction to do anything, I think it would have been, I think it was a surprise to him as it was us that there were 7 on there. I have one more question, if I may, to Mr. Goddard, as he's kindly turned up tonight and give his presentation. The 4009, Mr. Goddard, as you know, we've been in discussion on that road in my patch for a while. No recordable accidents, but many accidents. And this particular part of the road, as somebody else pointed out, is quite quick. And then all of a sudden you're hit with the roundabout, turn left, right, or go straight on. Could you just talk us through what considerations you gave, if any? I think I got the impression there was no need to, but it was brought up on the site meeting concerns of the speeds of the car coming down the 4009, which has got that reputation of maybe slowing down or again, you've got your rules as to where you can put your speed signs, but doing something before that junction, because I think there was concerns, maybe it is only 3-4 movements a week or whatever, but pulling a caravan out of there on that fast piece of road might be a concern. I know it was on the site meeting. Thank you.
Thank you, Chairman. The measurements before you take account of the situation as we find it now. It was mentioned earlier on that the speed limit changes fronting the site, and that's absolutely correct. It's not 30 miles per hour, it's nearly 38 miles per hour. So we've recorded the speeds as we found them and then provided the sight lines, or as per the plan and as per the condition, to that speed. So we're proposing sight lines that take account of the higher vehicle speeds that you would expect at the start of the change to 30 miles per hour. So the sight lines have been provided to the situation that has been found within the site. Thank you.
Thank you, Mr. Goddard.
Were you different?
I do. I'm panicking about this 100 meters because I'm just looking at Google Maps while I'm sitting here, and it's not much of a bend, but there's a bend to the right, which means my sight lines, I'm going to have to remove more and more of the fence or the hedge to be able to get the visibility displays. Am I not, or what am I missing?
What I will say to you is that 100 meters, it's 2.4 meters from the edge of the carriageway within the centre of the access. But as you get further north, that line, at 100 meters, meets the edge of the carriageway.
Yeah.
So the northern part of that probably wouldn't touch the hedge because it'd be much closer to the edge of the carriageway. But immediately to the south, immediately to the right of the access, the first 40, 50 meters, yes, there would certainly need to be some hedge that would need to be cut back, trimmed and maintained accordingly.
So I don't need to panic about the 100 meters.
It's not a whole 100 meters, no.
But maybe 50 or 60 of it goes. Okay. So,
yeah.
And you didn't mention to the south side, display on the south side, but I assume that's as much as you can, is it?
Yeah, the south side, because of the roundabout, it's drawn, it goes into the roundabout, so it doesn't actually affect anything to the south.
Thank you very much, Mr. Geller.
You're welcome.
Well, members, have we exhausted all the questions to officers? If so, who is going to open up the debate? Okay,
I'm quite happy to be honest. To be honest, I'd say I did start writing extra conditions down because, you know, when I first looked at this, the needs of that community and so on and so forth, they need to have availability of a life somewhere. So no problem with that at all. So shall I get that condition out before I debate, or because I don't?
Well, it's in a general.
It's in general. I mean, one of the things that strikes me about this whole community debate is that there's no real protection for the people in that community to make sure that people occupying the site are really from that community. As far as I know, there's no register kept, or, you know, I don't know if there's any it's just self-determination or what goes on. So I was going to ask to put in a condition that a registry should be kept available constantly to the parish and district council, where those that were occupying the pitches could provide evidence that they really belong to the Roma community or the Irish travellers or the other various protected groups that make up that community. Because if the wrong people are occupying the sites, then we're gonna have to find even more and more and more sites for the people that really need them. So I didn't see much harm in putting a.
Can I just stop you at that point? I think it might be appropriate. Is that a position that can be imposed?
Want me to answer that, Deborah? We would see that as an entirely inappropriate condition. It wouldn't be enforceable.
Unenforceable, right? I was trying to protect them. So
no, that's not the point, Councillor Abbs. The Gypsy and Traveller community are self-determining, and there is no way that the planning authority, as a public body, could determine XYZ is a member of the Gypsy community. For example, someone who may not be a member of the Gypsy community marries into a member of the Gypsy community, and so on. Also, it's, to be blunt, it's a resource issue. It would be extremely difficult to monitor that and enforce it. And also, if permission is granted, it is not a personal permission, it's a change of use of the land.
Right.
And therefore, the Gypsy community and travellers can move in and out of the site at their will, so long as no more than 5 pitches are occupied at any one time, because that is something that is nearly enforceable. Thank you.
Okay, well, on that basis, I'll carry on where Matt.
Thank you, Chair. In terms of the occupation, the condition 4 that we've recommended in the committee report, that is a standard condition that is normally inserted on appeal as well. So, I mean, that should be sufficient in any case. And I agree with I concur with Michael in that any condition specifying a register of occupants of the site would be unreasonable and very difficult to enforce.
Yeah, we did it at Lower Farm for the caravans there. So the register is supposed to be kept all the time. So I'm a little surprised by what you're saying, but moving on, that was there to try and help the community, not to do anything else. I think I'm minded in the end, and the thing that's convinced me to essentially argue against this being allowed is we keep hearing about the special area this sits in, and we keep hearing on balance we're not going to do much harm. But then one of the officers, Mr. Goddard, has made it very clear that we don't just lose a couple of yards of hedgerow, we lose approximately half of the whole distance. And who knows what, and then it's got to be maintained and so on and so forth. There are other issues there when we were on site that I don't think even that 1.5 meters, I did not feel safe walking down to the roundabout. I think I even noticed Mr. Butler kind of stand back while a lorry passed at one point to rejoin us. So, and that was on an area where in theory should have been okay. So I'm not convinced by the safety aspect. And if there'd been some way or this applicant had spoken to the Parish Council, which, yes, it's outside their red line, but the Parish Council building is literally just across the way. They could have easily had a conversation. They had easily have brought this forward during the planning process. And given the special designation of this community, I'm sure it would have been looked at officers in a favourable light. But so given the actual significant harm that's going to be given to certainly part of the ecology that's there, and given that this is clearly something that has come forward with the intent of breaking, and we have the Secretary of State saying no, we need to be fair to this, and we've got to have some faith in the system. Well, to be honest, there's not showing any there's faith in the system would say, I'm sorry, like everybody else, you'll be refused by doing this deliberate act. And I don't think that's doing anybody harm. It's just giving equal balance to the situation. Everybody else faces the same. So if someone proposes it, I'm the first one to speak, so I won't propose, but I will be supporting rejection of the officer's recommendation for the kind of reasons I just gave.
Right. Ward Member, Councillor Dick.
Thank you, Chairman. I'd like to just make a few general remarks and drift then into the hardcore. So there's been an awful lot of complaints, and these people aren't here. And the people who've come to me with their complaints, I would listen to anybody who's got anything to say about anything in my ward. I say, come, put it in writing, put your name to it, and come to the meeting. Every single one of them to whom I spoke, they're not here because they're frightened. They're in fear of some sort of retaliation. Now, I said, well, you've no evidence of that. There's no proof of that. I'm sorry, I can't really listen to that. So put what weight you consider appropriate on that. But otherwise, there would have been a lot of people here. Just picking up expressions from the report. Highly contentious. Numerous requests for information not forthcoming. Public confidence in the planning system can be undermined. We hear from the officer that one of the driving forces of his thinking was the shortage of pitches, and that's a concern. Of course it is, and frankly, it sounds like the council's been negligent in its duty. But that can be resolved by the policy people, get something in their policy and plan for it. But it's one. It's one. It's not significant. It is for that one. We've got 5 years. And then there's the national landscape. And there's an LVIA which read okay. Now, I know this site. I walk past it 5 times a week. I read the LVIA and I thought I've missed something here. And then, of course, the council's own specialist absolutely rubbished it. Rubbish. I've never seen such a critical professional document of another professional. These people swim in the same pond. They'll know each other probably. It was kind of shocking. It really was. And so that concerns me a great deal. A great deal. What else? there's an awful lot of conditions here, and we hear there's lack of clarity about drainage conditions, for example. There's more to come there. There's an awful lot of drainage, things to be done, and there's still a lack of clarity about sewage and so on. I do want to pause and thank Mr. Butler and his colleagues, because they've worked hard on this and they've done their very best. And it's nothing other than reflecting my view and reflecting the view of my ward residents. So thank you, officers, for the work that you've done. But the original arrival was under cover of dark, as we've heard. It was illegal. There's a High Court injunction there. Query what happens next of the breach that we've heard about. Public confidence in the system. The applicant hasn't really engaged at all. The officers had to chase and chase and chase. When we got to the site meeting, unheard of. We couldn't find him. He wasn't there. The residents of the caravans didn't know who we were. They weren't expecting us. And again, it's the same tonight. So I'm anxious, if that's the level of engagement, what about these very complicated and onerous conditions? Very onerous. Are we setting somebody up to fail? And we're outside the settlement boundary and we're in the national landscape. I think I'm giving you a clue as to what I think.
Thank you for that quite clear explanation and your thought process, Councillor Dick. Right, Councillor Amathraj.
Thank you, Chairman. Okay, to start with, on the technical aspects of this application, I agree with most of the points mentioned by Councillor Abs and Councillor Dick. It's mentioned by the officers that there's a flawed drainage plan, it's illegal, unauthorized, there is mention of intentional, it was intentional, and then all of these have to be considered for this consideration. I tend to agree with that, all of those aspects, because the officers clearly answered my question, where it was a point blank question of if it is another application, it would have been rejected, plainly rejected in the Greenfield site. But just bringing to this debate two aspects. There's no clear answers for our questions on the injections or enforcement. So I'm just thinking if we were in a position to refuse this, then what kind of enforcement? So in a way, the answer is, yeah, there will be an appeal, potential appeal. And what I'm trying to come up with is there wouldn't be any changes to what is there in the site if there was a refusal. So there's continue to have the same, if I'm right, the residents of the Hermitage Parish would have their concerns not mitigated at all. So we are not at this committee trying to address those concerns by refusing. So that condition wouldn't change. And further, I would bring all of us to the attention of the Part 2 information we have been provided. So there are some considerations to be made looking at this one as well. There are humanitarian consideration. There is mention of all the CECHR. So going by the technical aspects of this application, yes, this would be straight away refusal and we wouldn't support officer recommendation. But there are other aspects. So that's where I'm still deliberating and I'm looking forward to hear the other side of debate from the committee, whether we have answers to any of those considerations. So if there are, then we should think about that one. That's where I'm thinking. I'm not saying that I should either way if Councillor Ab's proposing a motion to refuse.
I didn't propose.
No, if you were to, I'm not saying that we should come to that conclusion, but I'm just trying to bring into the debate those two aspects. Let's think about that enforcement action as well, and also the Part 2 information as well, because that's not been discussed so far. And we're not going to the specifics, but let us take into consideration. That's my point so far, but I'll come later.
Chairman, if I may, because the Part 2 keeps being meant, there is stuff in there that is, as Councillor Amathraj is absolutely correct, that we could consider, but we can't consider it right now in this debate.
Councillor Abs, I did respond to Councillor Wollaston early on in the proceedings that if it was a wish and there was something relevant that you wish to consider within part 2, you've got the right to.
Well,
propose.
Councillor Armitage has just indicated that there are
Well,
things in there.
but he hasn't formally
Oh, he hasn't.
requested it. But if he feels he'd like to formally request it because it was appropriate, then we will take it forward at the stage if it's supported by other members.
In that stage, I would formally request that one, Chairman, because there is a lot of information in this in part 2, which clearly needs to be considered.
Okay, and you feel it's appropriate at this moment in time to, before we get into a formal debate, further along the debate, that we need to go into part 2. Is that what you're proposing?
We'll leave it to your judgment.
No,
Chairman.
I'm asking you specifically if you feel it's appropriate to propose.
Mhm.
I'm going to look around the table for a seconder, and we got a seconder. Okay.
Chairman, can I ask a question? Obviously, I've read the information we're talking about. I've read it. It's clear. It's there. We've all read it, I would assume. So we're all taking it into account. I'm not clear. Presumably, we'd have to clear the chamber, et cetera, et cetera. I'm not clear what having a discussion about it would achieve.
Well,
I just asked that question.
unfortunately, I don't, and I don't think other members do it until we get to that point. It might be appropriate. And
I
I
just
just
say,
turn to.
there will be a vote. So if members don't want to go into part 2 to discuss it, they can vote against that motion.
We have had a proposer and we've had a seconder. So I think I'm from the chair can ask, would you like to take, I'm going to ask you to make the appropriate vote at this particular point. All those in favour of moving into part 2? 3. Against? 3. Okay, I'm in a very difficult position. It's quite a contentious subject. I think it's appropriate that we should listen to what comments, if it's appropriate to help the debate. So I'm going to formally support that as well. So at that particular point, members of the, so I'm afraid we go into what is called part 2, where we need to discuss other aspects of this application. And unfortunately, I'm just going to have to ask you to just leave the chamber. I don't know how long it'll be for, but we will notify you as soon as we return to Okay. Right, we're going to recommence with the debate and which member wishes to continue on discussing the application? Councillor Abbs, were you going to come back now? No.
I can say, yeah. I like Mr. Powell, I have nothing at all against our gypsy and traveller community. In fact, I had a caravan myself and went away for wonderful holidays, and it's a very carefree life, and one might say one might envy them with the carefree way that they appear to live. They've got their problems like we have, but and in fact, I was looking forward to going to see this site, having looked at the plans, as I've already mentioned in my questions, and also after, and correct me if I'm wrong, having gone to a very similar situation at Emborne. Again, retrospective. Sorry, Washwater. Yeah, thank you. And I was really very impressed with the way that site was presented to us. I know it was retrospective, exactly the same. The gentleman was on site, answered our question, well put out, good fencing, hedging, everything was kept very, 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 very tidy. And as I say, I was hoping to see the same at Hermitage, and unfortunately, that wasn't the case. And I do feel that the applicant agent, whoever that might be, didn't do the best to help themselves, because perception is quite important, as well as our policies that we take into consideration. But the perception is very important. And if you remember, we went onto the site and it was for 5 vans. And straight away we picked up there was 7, might have been 8. One was dilapidated and broken down, but more than there should have been, which if you're trying to make a good impression, you thought there would have been 5 vans on the site for a kickoff. Walking around the site, the water was being provided, I think, to site 5 with a hose pipe, which was broken. And it was flooding the water, the drive which we had to walk up, this fountain of water coming out of the perception. The power box with the extension lead running to power caravan was open to the elements, not safe. The sewage tanks were open to the elements, not sealed. There were skips full of rubbish that needed emptying. Not a good impression. On plot number 1, there was, I felt, no consideration in the fact they'd parked the caravan very close to Tor Cove. Having had quite a large site there, it could have been on the northern side, but it wasn't. It was right on the boundary, and with that went the toilet facilities. Now, whether or not the sewage tank had been equally excavated and put alongside, which I didn't look, but very close again to Tor Cove. This is a retrospective application. It is in the national landscape, and it will have a visual impact. And we've heard and read the documentation of the officers of that issue. If this was a residential site, as we've heard, and I know the policies are completely different, it would be refused. But this is being recommended really on, obviously, the traveller and gypsy policies, but it's really on one issue, the fact we appear, although that's been in debate, short of sites. And that's overridden, I think, a lot of the consideration on the recommendation for approval. And as we've heard, maybe it is the council's responsibility for finding these sites. And I don't think it would be right for us to consider, and I'm still open to further debate, to approve this at the sacrifice of the residents of Mrs. Tor Cove, whoever she may be, 88-year-old lady, who's really taking the brunt of this because we possibly haven't provided enough sites. We are elected councillors. We do represent our constituents. 65 objectors here. We've got to take their thoughts into consideration as well. And if we vary too far from our policies, then somebody will come down on us and say our decision has been made for the wrong reasons. But these people have got to live with this. And we're here to represent them, tempered with our policies and tempered with the debate and tempered with considering all the other issues that we've discussed in the closed period. So that's my overview. A little bit of a ramble, a little bit of a wandering through, and not all totally, hardly all, driven by policy. It's one of perception, one of looking what is going to happen going forward, having seen that site. And I leave it to you as to where we go from here. But that's my thoughts, having been on the site and listened to the debate. Thank you, Chairman.
Well, thank you, Vice Chairman. I think, and obviously you were speaking to other members of the committee on some of those aspects, because immediately one can relate to the points which I picked up when I went on the site visit, and very much in line with what you were saying. So, I think it's useful for you to highlight a lot of these points, because there's obviously two members of the committee tonight were not actually on site on that particular morning. In fact, three of you were not available to attend. So I think it's very helpful that you've pointed out some of these aspects of what you noted. Anyway, going on around the table, Councillor Wollaston.
I'm sorry I wasn't able to attend the site visit because I was on holiday, but I did go today. Actually, I went on site and had a look around, and I certainly concur with Councillor Hooker's observations. It seems to me that the issue really revolves around whether we need additional sites or not. And over the next 5 years, we need one site. So why would we give consent for 5 sites in the national landscape? It seems to me as well that if we are to allocate sites going forward, which we obviously have to, it's our obligation, they should be probably in the area that's not national landscape. And I don't think we can avoid the comments from the Parish Council and the sheer vocal disagreement with this proposal from the local community. So I would like to propose that we reject officer's recommendation.
Do you, yeah, okay.
Okay, I'll look for a second, and then obviously we talk about the.
Or can we have the reasons first, so people know what
reasons.
they're seconding? So obviously landscape.
National landscape, and the council is not obligated to find 5 sites.
And also, of course, the effect on the national landscape and the local amenity.
I think there's going to have to be some probably added, like drainage, but.
Drainage, yeah.
Can I suggest reasons if you want me to, Chairman?
Well, okay, I've got 2 other members, and I'm just wondering whether they're actually going to come up with other suggestions as well. Right, I'll come to you, Councillor Farage.
Okay, yeah, it's a planning balance and conclusion planning balance. We're here to give different weights. So 7.82, I give great weight to. So the environmental impact, whereas it's down as, I'm sorry, not very. It's okay for me. Now I've heard about the up to 100 meters of hedge being lost. I give more weight to the harm that will be done there. So those were the main 2 weighting changes that were in my head, which changes my decision, very much an open-minded decision, as you could tell by the condition I wanted to put in, to come down, unfortunately, in this case, on the side of supporting what Councillor Wollaston has just recommended.
Thank you, Chairman. I do apologise again. I've missed the site visit. But as Councillor Wollaston, I did drive this afternoon lunchtime, but I was not able to enter the site. Just parked there and looked at the accessway. So I can see the accessway issue, but I could understand more from Councillor Hooker's description of the actual site, which is alarming. The conditions and all this stuff is alarming. I'm also giving weightage to two aspects in addition to the other things I've mentioned. 7.83, which is it seems to be an intentional unauthorized development. So we should consider the consultant's report on the ecology, not on the ecology side. It's 7.50 for the submitted LBIA. So I would support whoever is proposing to, or anyone proposing the.
So Councillor Willison's proposed, we've got some reasons for refusal. I think we were just seeing if anything was missed so that he can formalise his proposal so that whoever seconds it knows what they're seconding. And then perhaps when everyone's had their view, officers can maybe summarise what he thinks your reasons for refusal are, and then Councillor Willison can concur, and then
I think it was outside the settlement boundary as well. Outside the settlement boundary. Is that down? No, it's not down.
I can't say, it's not down. I've got harm to the NDL, but I haven't got outside the settlement boundary because that would be, I would strongly advise members against that reason for refusal because we are assessing it against policies CS7 and TS3, which are permissive policies for such sites outside of settlement boundaries.
Further points, Councillor?
Yep, something was visible on site was the noise being generated, not the noise onto the site, the noise generated from the site in a dark area effectively, which is so, and there was a generator running if members remember, and it was fairly noisy. So, and there was there's nothing in the report about the noise generation from the site, but there's also the addition of no commercial work. But I was very concerned about how you cross that with homeworking, with that's still a commercial enterprise if I'm running an IT business from home, is it not?
No, I can answer that. If you're running an IT business from home, that would be homework and it wouldn't necessarily be classed as a change of use of your.
But it says no commercial.
Yeah,
the condition is no commercial. So that
no commercial activities should take place on the site, but that wouldn't obviously preclude them parking vehicles associated with commercial activities on site.
I always thought I ran a commercial business myself in IT, but never mind.
Chairman, can I interrupt as case officer? Can I helpfully suggest what I think? I mean, obviously this is contrary to my recommendation, but I've got to bear in mind as the officer, if the council does refuse this, and it does go to appeal, which is likely as it's retrospective, the reasons for refusal need to be defensible. So I would, and this is obviously without prejudice, suggest 3 technical reasons to the committee, which I think would be defensible at this stage, whether they agree with that. Would that be helpful, Chairman?
Chairman, I was going to
bring you in anyway.
I was going to suggest just that.
Yeah.
Because he's heard the debate.
Yeah.
Heard what we said.
Yeah.
He can put it
I was going to ask Michael to ask this one, because at the end of the day, I think Michael's just making the most valid point. It's got to be substantial and it's got to be relevant and appropriate. Right, over to you, Michael.
So first one is clearly visual impact on the LDL, because that is a relevant issue and that's been covered in the report. And that, as you clearly said, is a balance view anyway. So that's sustainable at appeal. The other one is the drainage, clearly, because that still hasn't been resolved. So that's technically sustainable. And the other one clearly is access, because at the moment it hasn't been improved. So it's a technical objection. What I would encourage the committee not to refuse the application on, but at the end of the day, clearly it's your decision, is the point about need, because there is an identified need. Also the point about intentional unauthorised development, because whilst that's a material consideration, my advice to you is that is a difficult reason to sustain at appeal. And the other one, as Deborah says, is do not please point to the fact that it's outside the settlement and on a greenfield site, because that relates to policy C1, which relates to housing, and this specifically is not housing. Policies CS7 and TS3 are permissive policies which do allow in the countryside. So you would put officers in a difficult position in sustaining a policy reason for refusal. Thank you.
Chairman,
Just
sorry.
1 minute. Does that meet your approval?
Broadly, yes, but I'm slightly concerned that we're not looking at the need that we have. It is only one site, and I'd have thought we could also say, down to 5 years, accept. I thought we could also say that that ought to be located outside national landscape.
Yeah, it's entirely your choice. I'm just giving you advice.
Yeah, I'd appreciate that.
Yeah.
Chair. Whilst it's only one pitch short over the next 5 years, we obviously, as a local authority, have to plan for the plan period. And there is a shortfall at the moment of 18 pitches, 17 in the long term and 1 in the short term. And those requirements are a minimum requirement. They're not an absolute, it's a minimum. So we have to consider which is why Mr. Butler is recommending, and I do as well, not to add any reasons for refusal about need. Thank you.
You're happy now, right?
I'm
Okay.
happy with that, Chairman.
So I'm obviously looking round to seconder. Yep.
Chairman,
Yeah.
just again, we're taking the officer's advice. The public confidence thing has been mentioned quite a lot. Should that be phrased in there or not? Yes or no?
I would advise against a reason
Fine.
for refusal on unintentional unauthorised
Thank you.
development.
Okay, right. Seconder. Oh, okay, Councillor Dick. All those in favour of the recommendation, which is against officer's recommendation? So all those in favour? Unanimous. Thank you very much, and thank you very much for all the attendees for this particular application. Feel free to leave if you so wish. I think in view of it being 8:50, 20:50, do you want a 5-minute recess before we endeavour to get to the second application? And apologies to people that are here for the second application. You know, if you just bear us out for another few minutes. Okay. Okay, members and audience, we are now moving on to item 4, brackets 2, application number 24 stroke FUL, White Hart Inn, Hampstead Marshall. I'm now going to formally invite Sian Cutts to begin her presentation. So over to you, Sian.
Thank you very much, Chairman. I'm just going to start to share my screen. There we go. Right. Thank you, Chairman. Just about no. Right. So this application is for the White Hart Inn, proposing a change of use of the public house to residential use, together with external alterations, landscaping, car parking, and other associated works and infrastructure. The application has come to the committee because there were more than 10 objections, and it's been recommended for approval. The application site is situated within Hampstead Marshall, which does not have a settlement boundary, so the site is within the open countryside and is also within the North Wessex Downs National Landscape. As you can see from the location plan, there are residential properties surrounding the site, and just to the southwest is the entrance. Here we go. Yeah, just to the southwest here is, can you see that? To the southwest, oh, sorry. To the southwest is the entrance to the Dogs Trust Homing Centre, and your other residential properties surrounding the site, north, west and southwest. Here we have the existing site plan, which shows the main public house building here, and this building at right angles, which provides additional bed and breakfast accommodation, and this building on the corner of the site, and this is a storage outbuilding here. You can just about see, with the beer garden, parking area to the front, and extensive parking area to the north. The application is proposing that the main pub building will be split into 2 units. This building here is called H3. That will be a 2-bedroom building, 2-bedroom unit, and H4, a 3-bedroom unit. You'll notice at the front of the site, the car parking area will now be incorporated into a garden for plot 1, and a new parking area is proposed here adjacent to existing access, and gardens and parking created from the car park area at the north of the site. Here we have the existing elevations of the main pub building. What is proposed to be H3, and the existing elevations of H4, which is the large building on the north boundary of the site. These are the floor plans of each of the units. And here we have the proposed units. So you can see this is the pub building, which will be split front and back. Here, H3, the infill that goes from the beer garden through to the car parking at the back, that would be infilled. You have a small bungalow here. And these are the floor plans for H4. And I'm showing you the elevations. There we go. Oh, sorry, here are the proposed elevations. And as you'll see, there are very minimal alterations to the buildings, mainly consisting of new door openings and windows. on this elevation here, you can see the roof light, which is on H4, which I understand you visited at the committee site visit to see the impact on a mansard house to the side there. Since the site visit, the applicant has confirmed that they will accept a condition that this window remains obscure glazed and shut, and that has been included within the update sheet. So this section just shows that window and the minimal overlooking, but with it being shut, then that then wouldn't occur. Here are the photographs of the sites. This is taken from the car park from the southeast. This is the view from the road, view from the parking area across the beer garden and into the car park. Sorry, this photograph's a little split. The building isn't quite as long as that, but I couldn't quite take a photograph that took it all in one camera screen. And this is H4. Some of these roof light windows would be removed. And this shows the setting of the car park and the outbuildings. And this is the existing access into the site. So these trees to the left of the access would be removed to create the additional parking spaces. Okay. If I just refer you to the planning history, which is set out in detail in the report. However, there was a planning application made in 2017 for a very similar proposal. There are only a few alterations to it in the current application. Now, that application was dismissed on appeal in 2018. In dismissing that appeal, the inspector concluded that at that time, there was insufficient evidence to demonstrate that the use of the building as a public house was redundant and that there hadn't been adequate marketing of the site. How this compares to the current application, I will address shortly as I get to my assessment. In terms of the consultation responses, which are set out in the report, the Parish Council have indicated that they are in support of the application. The Highways officers raised no objections. The tree officer initially raised objections, but following the receipt of additional information, now recommends conditional approval. Archaeology, drainage and ecology also request conditions. In terms of public representations, since publishing the update report yesterday, we've received 2 additional representations today, one in support of the application and one objecting. So we now have a total of 35 representations, 6 in support of the application and 29 objections. The new representations don't particularly raise any new issues. The issues that have been raised in support and objections have been summarised within the report. Although to remind members, I'd say that general points in support of the application are that the site has been well run in the past with a good food and drink offer, but very few people supported it. And given the location, it was difficult to increase footfall. View that there is need for more housing than a public house within the area. The site has suffered from competition from town centre pubs and restaurants, and that there haven't been any sensible offers to purchase the site as a community asset. In terms of the objections, there's objection due to the impact on privacy of the neighbours from the skylight from H4 overlooking neighbours, concerns about loss of trees, concern about drainage on the site. Comments have been made that the site could be run as a community pub. The sale price, marketing and state of the buildings have been questioned. Some people have suggested the business model of the pub was not working. There was a poor food and drink offer. It was suggested that the RICS Red Book valuation should be provided. Reference has been made to other rural pubs that are viable and thriving post-COVID. Objections to the loss of a community facility and potential employment on the site. Objections about lack of marketing information, the guide price in the sale for the sales, and that it should be an asset of community value. That it doesn't meet policy requirements or overcome the previous inspector's reason for dismissing the appeal. Intermittent opening of the site. The pop-up cafe and pub in the village aren't a suitable alternative to the White Hart, and that it could also be used for social enterprise use. I turn to my appraisal of the site as set out in the report. The main issues in determining this application are the principle of the change of use, the impact of the development on the character and appearance of the area, impact on residential amenity, highway safety, heritage, trees, and ecology. So if we take the principle of the application of the development and the change of use first of all, policy C10 says that applications which propose the loss of small enterprises in the countryside need to demonstrate that they will not have an adverse effect on the local economy. Policy C1 sets out the conversion of redundant rural buildings to residential use are acceptable. And policy C4 sets out the criteria for the conversion of redundant buildings, and firstly say that they need to demonstrate that the building is genuinely redundant for that use. And there is also advice in the Public Houses SPG, which sets out guidance for assessing applications which result in the loss of a public house. So, as I previously stated, there was a similar application which was dismissed on appeal in 2018. And so that decision is material to this application. The main reason that the previous application was dismissed was the inspector considered that it hadn't been adequately demonstrated that the building was unviable. A different business model could have been used, and also that the marketing campaign that had been taken at that time was not robust enough. It had only, there were issues that had been identified within that. In this application has been submitted with a community resource analysis report, and this has set out alternative community facilities within the area, information about trading information since 2018, the marketing campaign that has taken place for more than 12 months, and alternative pub provision within the area. So there are 5 other pubs within a 2-mile radius of the White Hart Inn. They are the Craven Arms, the Furze Bush, the Halfway House, the Dundas Arms, and given the way Hampstead Marshall is laid out, has developed historically, the White Hart Inn is realistically only accessible to some local residents by car. And so these pubs offer alternative facilities which are easily accessible. You know, once if you've got to get the car to go to the White Hart Inn, well, actually, it's just as easy to go to some of these other local pubs. The analysis information which was received, the council also had independently reviewed by our own consultant. He agreed that with the site no longer being an asset of community value as it was in 2017-18, and due to the rural location, lack of draws within the village for any visitors to come, the other community facilities, economic changes since COVID, lack of potential visitors, together with the marketing at an appropriate value, and different tenures. The public house is offered is on different tenures. That those the inspector's reasons for refusal have been overcome. He was satisfied that that the White Hart is no longer economically viable as a pub, and that it has been appropriately marketed. Particularly as the site is no longer an asset of community value. There was an application to renew that listing, but that was refused as there was insufficient evidence to demonstrate the importance of the White Hart Inn as a community asset. And as we're aware, changes post-COVID to the in the hospitality industry, the cost of living crisis and things have also affected the long-term prospects for the viability of the public house. And so we consider that it is truly redundant as a public house, and its loss will not be detrimental to the rural economy. So as demonstrated in the proposed elevations, as we consider the impact on the area, there are just minimal alterations to the appearance of the windows. These are mainly limited to window and door alterations. There's no extensions proposed to the buildings themselves. And given the changes to the layout of the site with the removal of the parking area to the front, additional landscaping, there may actually be some visual improvements to the appearance of the sites along the road. In terms of the heritage, the alterations are sympathetic to the main style of the building. Historic fabric within the building will be retained, and archaeology have requested a condition requiring building recording to take place before the works commence. And together with these conditions, it's not considered that there will be harm to this non-designated heritage asset. In turning to residential amenity, as you're aware, there's been an objection to the window, the skylight window on property on building H4. But as mentioned, we had originally recommended a condition that the window is positioned more than 1.7 metres above the internal floor level to comply with what would otherwise be permitted development. However, the applicant has now suggested that they would accept a condition that this is an obscure glazed non-opening window. And that has been, the wording of that is included within the update sheet. There was also another objection received about the window on the east elevation. Sorry, I'm on the existing, sorry. Okay, I was on the, so there's the window, and that will be a shut obscure glazed window. There was an objection received about the window on the east elevation, but this is an existing window, and so it wouldn't be reasonable. It serves one of the guest bedrooms, and it wouldn't be reasonable to put a condition on that window. In addition, there is a tree in the neighbour's garden, which also screens it from views. The garden areas for each of the houses also accords with the council's minimum requirements for space. So we're quite satisfied with that, the amount of amenity space for each dwelling. In terms of parking, there's sufficient space within the site to provide the parking requirements of P1, and conditions have been recommended to secure the parking spaces, cycle storage, electric vehicles, surfing of the access and visibility displays. The update sheet contains an amended condition for the visibility displays, and in discussing the wording of this condition with the applicant agent and the highways officer, we're now proposing a further update to that condition than was proposed on the update sheet. We're suggesting this is now changed to the existing access and visibility display will be retained within the site in accordance with the approved plans and therefore thereafter be kept free of all obstructions to visibility above a height of 0.6 metres above carriageway level. Ecology, there is evidence of bats within using the building for roosting. The ecologists have reviewed the report that has been submitted and they are satisfied that with conditions for bat mitigation during construction and a lighting strategy and other conditions, this will be fine and the bats will be happy. So as set out within the officer's report, it is considered that there have been material changes in circumstances since the previous application on the site was dismissed at appeal. These have been the changes in the hospitality industry as a whole following COVID, and also the additional information which has been submitted to demonstrate the site is no longer viable as a public house, and the marketing information that has been provided. So the proposals are considered to accord with the development plan policies as set out in the report, and the application is recommended for approval in accordance with the conditions as updated in accordance with the conditions in the update sheet and the visibility display as I've just mentioned to you. Thank you, Chairman.
Thank you very much, Sian. Paul, any comments to make?
Thank you, Chairman. I would say not on this occasion. I think my colleague has covered all the points I wanted to say. Are you?
Thank you very much. Okay. Right. We now move on to the speakers on this application. And as I said in the earlier application, you have 5 minutes each speaker, and we will notify you after 4 minutes. Now, the first speaker, I think, is Anne Budd, who's already sat at the desk. And I'm going to give you a dispensation to remain at the desk, Anne. And you can obviously start your presentation when you're ready. Is the microphone working? Okay.
Good evening, ladies and gentlemen, and thank you very much for consenting for me to address you this evening. I am Anne Budd. I am the chairperson of Hampstead Marshall Parish Council, and I'm here representing the Parish Council's views and decision in this matter. My declaration is I have not been lobbied by anyone, and to my knowledge, neither have my Parish Council colleagues. The Parish Council, at its extraordinary meeting dated April the 25th, 2024, came to the unanimous decision not to object to the change of use application based on the following facts in evidence. The pub closed in October 2022. I think its last trading was at a private party on the 30th of October. Since that time, no customer transactions have occurred, nor has the pub nor has the pub traded. There is no local interest. In fact, local interest has abandoned the White Hart Inn not once, not twice, but 3 times, 2009 to 2010, 2015 to 2016, and lately 2022. Local interest, as I'm sure you are aware,
is the last vestige of a pub's lifeline. Now, some of the former customers of the White Hart Inn now frequent the Craven Arms at Emborne, which is approximately under a mile distance from Ashtree Corner, which is at the centre of the village. The Parish Council understands that a community space like a pub is very important. However, Hampstead Marshall is not known as a sustainable location, for example, its services. We have no retail outlets. We have a village market once per month held in the village hall, and we have a parish cafe, again, once a month in the village hall. The Localism Act, asset of community value, no longer applies to the inn's premises. The sobering thought which I respectfully place before you this evening, whatever transpires in this honourable council chamber or anywhere, come tomorrow morning, the pub's buildings are still in disrepair, the pub is still closed, and there is no pub business. The situation begs the most salient of planning questions. Thank you.
Thank you. Questions? Okay, Councillor Amos Raj first and then Councillor Abs.
Thank you, Chairman. You mentioned about the community as value asset no longer in place. Could you please explain that a bit, where that has expired in terms, if I understand from doing some research, that this White Hart Inn was confirmed as an asset of community value way back in 2016. I understand there is a 5-year period, so it would have expired recently, I mean 3 years ago in 2021. So, and I also understand it would have been applied through the Parish Council. So can you take us to the committee in terms of when you mentioned no longer applies, is it the view of the Parish Council where that it's no longer a community value asset and they didn't renew it, or they didn't, you didn't, for example?
I'm happy to do that for you, Councillor. In fact, it was I that made the first application of asset of community value, which was accepted. Once the time was running out, another parish councillor did submit an application, but the evidence was that there was no justification that an asset of community value would be appropriate. That's as far as my detailed knowledge.
Thank you. I think you answered my question. Thank you.
Okay, Councillor Abs.
Yeah, thank you. On the site visit, you mentioned about no trading going on at the pub at all, but
I'm sorry, sir, I can't hear you very well.
Oh, really? I'm sorry. You mentioned that no trading was going on at the pub, except for at the site visit. I believe it was the applicant was wearing a T-shirt about brewing and offered to show us the brewing facilities. Do you know whether or not the brewing was going on site, or?
To my knowledge.
To your knowledge, yes.
There has been no brewing.
Okay, thanks. Well, I'm sure the applicant will pop up in a minute. But,
Okay, thank you. No other questions? No? Okay.
Thank you very much.
You're going to switch it off, Sam. Okay, right, I'll now call upon the objector. And in your case, is it Mags? Okay, if I can ask you to come to the lectern, okay?
Is that working okay?
And you can commence with your speech when you're ready.
Lovely, okay. And thank you for giving me the opportunity to speak. And my wife and I, Claire, we really appreciate you coming to the site visit and coming to our site at Mansard House. So we've lived there for the last 12 years with our 2 sons, and we're obviously drawn to our property because it was very not overlooked. It was a lovely area, and we've really tried to support the pub over the last 12 years. And actually, we definitely haven't abandoned it. And I have that feeling that many other villagers haven't abandoned it. But and at times it's been thriving and doing really well. And I remember when we first moved in, it was very busy. So, but I also do appreciate business, and I understand the situation that Stella's been under and the pressure around costs, etc. So our objection is very much around the skylight, which directly was overseeing our property. In 2017, when the original plans got put in, we had no objections to the planning because there was no skylight. So actually, I don't know if the internal settings of property H4 only had 2 bedrooms, maybe rather than 3, but there definitely wasn't a skylight on the plans for looking over our garden. So whilst I appreciate the conditions that you entered in yesterday around it not opening and the other side of it, you know, we definitely still feel it's an impact on our property. We believe that it's going to impact the resale value. We believe that the actual desire for someone to maybe move into property with a skylight there, even though it is non-open and opaque, worries us. So our request is to definitely either revert back to the previous plans where there was no skylight, or enforce that there isn't a skylight at all on the property, because we do believe it's going to impact us.
Okay, that's your presentation, your comments.
I didn't want to take 2 hours.
Right,
first.
questions? No? Okay, no. Oh, right, Councillor.
Yeah, if you don't mind, I'm a bit, sorry, sir, I'm just slightly confused. If the window won't open and it's obscured, how is anybody going to look in and look out?
I've got an obscured window in my bathroom and I can still see through that. So I have concerns with that you can see shapes, you can see things. And my belief is, and we've spoken to a few of our friends who were looking at properties, if there was a skylight visible looking into our property, even though it is non-opening, we believe it impacts our value of our property and our ability to potentially
unfortunately, value is not a planning consideration.
No, I appreciate that. My ask is what's changed from the 2017 plans why could that not, where that didn't have a skylight?
Well, we can only look at the plan in front of us. So, sorry. There.
Okay. No other questions? Okay. You can return to your seat. Okay. I now call upon the supporter, and it's Chris Moss. Is that correct? Yes. Okay. And again, you've got 5 minutes, Chris, and 4 minutes will be notified to you when you get to that point.
Thank you, Chair. I wish to support the change of use as the pub restaurant has not had proper support from the village for at least the last 10 years or more. It was certainly a community space, an asset 60 years ago. They used to run auctions and all sorts of things, but things changed in 60 years. It's not had that support for many years. And with the decline of pubs across the UK from 60,000 in 2003 to around half that number today, I'm surprised it's lasted this long. Cultural changes, smoking bans, drink driving rules, staffing costs and rates and energy prices all take their toll. Supermarket pricing and the cost of living crisis all continue the downward trend of the number of pubs being frequented across the country. Over the years, more than half the pubs in Kimberley have gone, and Stockcross lost all 3 pubs. I looked at the objections and it worried me a little bit, but when you read them, many of the objections are disingenuous and factually incorrect. I can go through some of those if you would like, but just one example, they talk about the bell in Boxford and the price it went for. Well, they actually demolished the whole building and they invested over 2 million in it. Wonderful place if you want a pizza, but the asking prices sometimes have nothing to do with what they're going to build there. From my point of view, my wife and I are some of the only people who've actually paid to stay there. When we first came to the area, we needed somewhere for a few nights, and we loved it there. The rooms were fantastic, and we really enjoyed the stay. The breakfasts are one of the best you get in West Berkshire. I can remember it to this day. And when I look at the time that we've spent there, we've sampled their delicious breakfasts, enjoyed fish and chips and wonderful liver and bacon, very difficult to find nowadays. And we've met friends for coffee there. But whilst we enjoy spending time there, we're living in Hampstead Marshall, and there are many other competitors. Within 5 minutes of my house, or say 5 to 10 minute drive, you have the Red House, the Craven Arms, the Furze Bush, the Rampant Cat, the Halfway Inn, and the Dundas Arms. And we'll go further than that. And sadly today, things are changing. In my world, you know, just like rural post offices, rural banks, phone boxes, there's change everywhere. Many of us try to resist that change. But sometimes, as in the case of Stella's best efforts to keep the White Hart open and viable, it's no longer practical or financially possible. Hampstead Marshall needs more houses. If we're going to thrive, we need those houses. I'm hoping that that's what we're going to get. Thank you.
Thank you very much. Questions from members? No, it seems you've got off lightly. Okay, thank you very much. And now I call upon Stella. Is this a joint presentation or it is? Okay. So, okay, but it's 5 between you, don't forget.
Exactly.
Okay, over to you.
Thank you, Chair. My name is Stella Colthurst. I'm the owner of the White Hart Inn. Beside me is Gareth Johns from Provision, the planning consultants. I renovated the White Hart Inn from derelict in 2011, paying £530,000 for the site and spending a further £700,000, bringing the pub and rooms back into life. Though an experienced businessman, this was my first hospitality venture, so I engaged a consultant friend who'd run the Harvester pub chain to help me set up a good operating model. Likewise, I employed experienced general managers to run the day-to-day operation of our mainly destination pub. My role then was predominantly back of house, but we tried to appeal to locals too, and I ran a wizard pub quiz. In quite a few respects, the pub had achievements. Our TripAdvisor and Booking.com scores were good. Those who got to us loved it, and we could be busy, but financially it was a disaster. The White Hart Inn was purchased from a mortgagee in possession, the previous owner having gone bust, and under my ownership, it has never made a profit. I continually made further capital investments and propped up the losses. Unable to sustain those losses, I closed the pub very late in 2015, but tried again in early 2019 with a revised format that added to our destination appeal, including our own brewery. Post-COVID, with the dearth of staff, I came very much to the front of house. I put one of the best breakfasts in West Berkshire, and you've heard that. Now with very high ratings, there was praise for the place, the food, the beer, the service, the team, me, and still a financial disaster. The cost of living surge was the final straw, and the sector continues to struggle. The world has changed. We take drink driving seriously. The pub as a social hub has ebbed away in favour of fabulous supermarket offers. Newbury has expanded its offer of rooms, hospitality and leisure. Little by little, that moves the White Hart Inn further and further away from its market. No one is sadder than me at the outcome. To sum up, I hand you over to Gareth Johns.
So focusing on planning matters. So the principle of the conversion of the buildings to residential use is acceptable, subject to demonstrating that the business is no longer viable. The council instructed an independent viability review of the application, which concludes that the property cannot reopen and be run as a viable enterprise. The property has been suitably marketed on both a freehold and leasehold basis since January 2023, more than the 6-month requirement in your guidance. The asset of community value designation has been removed. The council's independent viability review also noting that Hampstead Marshall is not large enough to support such a business. As Stella has explained, there's been significant declining trade despite several relaunches over the years. It also been demonstrated the property would never meet the CAMRA criteria of a viable business and would continue operating at substantial losses. These conclusions are supported by the independent viability review. The White Hart Inn is evidently no longer a viable enterprise and would not result in the loss of a valued community facility. There is no in principle objection to the conversion of the buildings for 4 much needed homes. The Parish Council is also not objecting, neither are there any technical objections from any consultees. Specifically, the heritage team has raised no objection. Works are limited and will retain the historic fabric of the main building. The tree officer has no objection and additional replacement tree planting is proposed. On highway matters, there would be a reduction in traffic generation and the proposed development would utilise the existing access. Proposed car parking is in accordance with the council standards. Following the committee site visit, the proposed skylight on the northern elevation of unit H4 has been agreed
1
to be
minute to
both
go.
opaque and non-opening. This is beyond permitted development rights. Further, there are no objections on ecology, amenity, design, and drainage matters. So in conclusion, we appreciate that the loss of a pub is not to be taken lightly. However, due planning process has been followed and the principle of residential conversion is acceptable. There are also no technical objections. We ask therefore that you accept your officer's recommendation to grant planning permission this evening. Thank you.
Thank you. Any questions to the applicant or the agent? Right, Councillor Amatharaj.
Thank you, Chairman. Again, question to you both. Just a clarification. You mentioned that it's been in the market for around 6 months. You don't need to divulge that. I'm just asking out of interest in terms of understanding whether there any interest from buyers to buy this pub and continue running this pub during those 6 months.
Yeah, no interest to run it as a pub.
Okay, there was no interest to.
No.
Well, yeah, it's just expanding on it. He just said no offers to run it as a pub. So there were some offers to do something with it then.
No, there were no offers as a pub. There were some inquiries. I took some people around. Some people thought they could see an inexpensive development opportunity and were clearly interested in the same reason.
Same as you're doing,
here.
yeah.
And I did take a couple of restaurant groups round who then didn't want to pursue their interest because they could see the location challenges.
Okay, but do you mind concluding on the brewery question? Just
The
we're
site
still wearing the
looks-
t-shirt.
Yeah, no, the t-shirt's great. The t-shirt has
T-shirt, very
lasted
good.
a bit longer than the other things. We put in the brewery. It's a 4-barrel brewery. You brew 1,200 pints a time. It's like brewing a posh cup of tea. You start with a load of malts and hot water, and then you throw.
No, not asking about the process that.
So the beer was very appreciated while we were open. There was a beer club and everybody had that t-shirt. No beer has been brewed even in the month before the pub closed. I was using Ramsbury
Yeah, okay,
ales.
thank you.
Okay. You can return to your seats. Now, Councillor Vickers and Councillor Gaines are LGA, I think. Is Councillor Bennyworth on? So, okay, so we haven't got the ward members' contribution. Okay, so it's questions, or comments to officers. Members, right, Councillor Williston.
It's Mr. Goddard. I just want to double check that there is enough or sufficient car parking spaces there for the size of this development.
Yes, Chairman, I can confirm that there is sufficient car parking for the development. The 3 2-bedroom dwellings require 2 spaces each, so there's 6 spaces altogether. And the single 3-bedroom dwelling requires 2.5 spaces. So altogether, 8.5 spaces are required, 9 are provided. So the proposal does comply with policy P1 and your car parking standards.
Thank you.
Councillor Dick.
Thank you, Chairman. 2 questions. One is, are there any issues about future development, for example, extensions, things like that? Is there room? Or do we need to be concerned about a condition to limit anything of that sort? Question number 1. And question number 2, the window. The only negative thing we've heard is the window. Can we hear a little bit more about it? What height it is off the ground, what angle it's at, etc. And maybe even why we suddenly need it. Thank you.
Okay. In terms of extensions and alterations to the buildings, given the layout of the buildings within the sites and proximity to gardens and things, permitted development rights would really be limited on the site because you've got positions of road frontages and things like that. So we haven't put a condition restricting any extensions and alterations to the buildings. It wasn't felt to be necessary, other than to restrict the rights for any other additional window openings along that north elevation of H4. Because actually, technically, under permitted development rights, you could even put ground floor windows in along there, which obviously would be wouldn't be acceptable. And actually, I'm not sure that any occupier would want to have people looking straight in from another garden directly like that anyway. So that has been put on as a restrictive condition. In terms of the window, if I just go back to the so we've got the proposed elevations here. So on this drawing, it's a bit obviously scale is such, it's a bit hard to see the writing on it, but by that window is a blue line, and that shows that the window is positioned, the opening parts of the window, when this drawing was originally put in, it was an opening window, and that shows it as 1.7 metres above the internal floor level. And these show the directions that you'd be able to look out of it. Now, this is the standard what you can put in under permitted development rights on a roof slope or a side elevation window of a dwelling house without requiring planning permission. So government standards are that this isn't going to cause overlooking. And so originally we requested.
Sorry, Chairman, just for clarification. No, you're doing a great
Yeah.
job. So the lower dotted line is the eye line of an average sized person. Is that it?
Yeah, looking out. So you would be looking up. So yes, this demonstrates that even with an opening window, there wouldn't be an impact. Does that answer your question?
Yes. Sorry, yes, except do we need it at all?
Well, yeah, as I understand it, this was originally proposed as a bedroom, so it's a building regulations requirement that there is an opening window. It has been suggested that they can make internal alterations, which is why the offer was made for a condition that it be a shut window. They could alter the layout so that they could apply, maybe it could be used as a bathroom and therefore only mechanical ventilation is required.
Okay. Any other points? Right, Councillor.
Just a bit of clarification on the roof lights on the front elevation of H4. It shows 7 on the front elevation. On the plan, the proposed site, it only shows, I think, 5. And I was a bit confused about those 2 are shown in red elsewhere. Is it 7 along the front or is it 5? I'm trying to find the drawing. Yeah, if you go on to that drawing, which is the proposed, it shows 5 lights. On this drawing, which is the proposed front elevation, it shows 7. Is it just an error? Okay.
I think it's hard to tell, but it does actually show 7 roof lights on the proposed first floor plan. I think the one that's probably
No,
not.
I'm on about the actual roof line, these. I've got a drawing.
I was looking at the proposed floor plan.
But here, it shows it there, but here it says proposed site plan. And then it shows 5 lights. This is the existing. Are they in or out?
So, yeah, on this one, the red shows the omission of the roof lights. if you can see that.
Yeah.
And then,
Front
I think,
elevation of that.
and then on this proposed first floor plan,
Yeah, I'm on the
it's-
front elevation.
yeah,
Down
on
the
the,
roof.
on the front elevation,
There,
uh,
no, not that one.
that one, they've been dotted in red to show that they're removed. So it's just the 1, 2, 3, 4. So yeah, they're losing the red ones.
Elizabeth, thank you.
There we go.
Further question?
Yeah, it was for Mr. Goddard, although Mr. Goddard did say it was to our policy. In a little development like this of 4 houses, virtually a cul-de-sac, there is only one visitor place. Is that, I mean, we've got enough parking for residents, but where do visitors go? I mean, there is another place you could put one in. It's not for us to say, but behind the outbuilding retained as a store, but there's only one visitor for 4 houses. I mean, normally one, if you visit somewhere, you stick it on the road, but here there's only one visitor.
Chairman, our parking standards are to provide 1 visitor space per 5 units. So it does comply, Chairman. Thank you.
Members, any further questions? I'm looking at the time. We got 12 minutes to go into debate. Are we going to complete in 12 minutes? Okay, right, over to you, members. Right, Councillor Amathraj.
Thanks, Chairman. I will start with the debate with the aim that start by proposing to approve this one. The reasons I'm saying is that I can relate to this case being a Spean Parish Council where in Stockcross it's mentioned that all the 3 pubs have closed. The one reason being the rising sun. We were instrumental in applying for the community asset value and all this stuff. But the gist is the pubs can only survive if there are customers and if there is support from the local community. If there are no support, it will close down. Unfortunately, we are not in a communist state. We are in a capitalist or free market. I believe in free market. So we can't force someone to run a business if it's not viable. So on that premise, I fully support the applicant's view that it should be converted onto something more viable. Since there are no major technical objections to this application, I'm happy to propose that we accept this proposal from the officers and propose that. So that's my point in jest.
Right, Councillor.
Yeah, I was going to say, believe it or not, I chaired the meeting in 2017 when this application came to committee, and I remember it very vividly, and I can't believe it's 7 years ago. And the reasons that the committee refused it on the night were the same reasons that the inspector refused it when it went to appeal. But I, as I say, vividly remember 30 or 40 plus people from Hampstead Marshall turning up in the chamber to make the case to save the pub. And I remember making the comment on the evening that my heart went out with them to save the pub. But my head said, how many of you 30 people are going to support this pub to keep it open? So I think we gave the residents of that village a very good opportunity to support the pub, but presumably that support as promised on that night hasn't been enough. So I'm quite happy to second this proposal to grant approval.
Bearing in mind, I think you were nodding earlier. I would imagine you want to probably make comments in support of Councillor Hooker.
Yeah, thank you, Chairman. And just like Councillor Hooker, I was here in 2017. I've been on this committee since 2003 when I first joined the council. And I remember the evening very well. And I remembered how disappointed the landlady was. I remember that. And maybe we should have made that decision then. And Clive says, but if all has been tried to succeed in the White Hart, then I understand the present owners wish to sell. So I'm in support of changing into housing.
The only thing I would say is that we agree or we don't agree or take the discussion any further with the light, the skylight. It's not gone as a condition.
Actually, if I was going to talk about that condition and that there are different types of obscuring of glass, so would prefer a condition that really obscures. I don't mean blacking it out, but you know what I mean. So it's in the vaguest of shadows that you can see through, and that should be pretty easy for the officers to go, yes, that right.
Is that something you can address?
That would be, it wouldn't be a normal condition, and I wouldn't think it would be reasonable because obscure glazing is such that it stops that direct visibility. Yes, you can see shadows of movements, but you can't.
They're not knowing
make out, and I think
but
it'd be-
obscure glass comes in very versions I've seen are basically a pattern that's in the glass, and if you get up close, you can see straight through it. Other types of obscure glass is I can get as close as I like, but I still can't see through it because it's a very tight meshed, very tight pattern. So one would be, I imagine, far more acceptable than the other. So maybe the applicant and the objector could have a chat about what would work for them. Not if we can't condition it, but I'd like to have seen a condition.
I would recommend that it wouldn't be reasonable because obscure glazing, most levels of obscure glazing obscure to a certain level anyway. So I would recommend that members.
Is there not
didn't
a technical
specify.
standard that
There-
we can
there
apply
is-
there?
Not that I'm aware of.
Okay,
Councillor
thanks.
Abs, I'm afraid.
Okay, are you happy with that?
Well, no, because
the best.
No, but
I mean, I think the consensus is probably very similar around the table. Your concerns, because overall, the rest of the issues I think have been addressed, and I think we're reasonably happy. But just finally, before I put it to the vote, right, Councillor Williston.
So one way we can make the condition obscure glazing to prevent any overlooking of the adjoining property.
That would be the reason anyway for the condition, which is stated in the reason to prevent overlooking.
I do take the councillor has a point. There are some obscure glass which is literally just sort of a pattern on it, and you can still see right through it, which clearly is not in the spirit of what we're trying to achieve.
We could specify, I'm not aware of different technical levels of obscure glazing. I understand Councillor Abs's point in that some.
It will take me 2 minutes to get my laptop back on.
I can look it up, but I don't have the answer, I'm afraid, because I don't know the.
Can we leave it to officers, though? You know what we're trying to achieve here. That someone can't see through into the adjoining neighbour's property.
Officers will look into that, and we will ensure that the condition is such that the obscure glazing is sufficient to prevent any overlooking of the neighbouring
And we have
property.
great confidence in the officers.
Well, we hope so, don't we?
And may I compliment Ms. Katz for her report and for her interesting.
Thank you very much for
Well,
that.
Chairman, if the glass
Yeah.
isn't obscure enough, we might see a Leylandi go up.
On that, we're 5 minutes away, so I think it's appropriate. We've had a proposal, a seconder, and obviously identified the condition. So are those all in favour of the recommendation? Okay, unanimous. For anybody on Zoom, it's unanimous decision. Thank you very much, members. Before I close the meeting, I think, Deborah, you were hoping to get some consensus on the site visits form.
Yes, thank you, Chair. At the moment, site visits take place on various days. We have Mondays or Thursdays, and it would be good moving forward if what officers proposing is site visits take place on the Thursday before committee as a regular, unless there is a particular clash with so that's what officers are proposing. It gives officers more time as well.
I'd like to support that.
I'd like to support that
as well.
Okay, thanks very much. Right.
It doesn't affect me, Chairman. I don't think we've got anybody on the planning action or planning.
I am now, but
if you're on PAG, it's going to clash.
But the discussion was that they were considering, as a part of this decision-making process, to move back to the afternoon.
Doesn't bother me, but
I think that's something we'll have to discuss, won't we?
But
Vice
equally,
Chairman?
PAG is only going to meet every other month now. It's
Yeah,
not meeting
yeah.
every month.
Finally, last comment.
Chairman, thank you. Just my comment on this one. Thursday should be good, just to previous week. But only suggestion is that can we arrange this visit around lunchtime-ish? Because I always have to take a break from the work, ask permission half a day. Sometimes it runs half a day. So is it around this lunchtime break? Or if it is not possible, leave it. But I'm just suggesting that during the winter months as well, like it would be good to have some kind of.
I think we need to have a discussion, two or three of us. But we're trying to take everybody's concerns on board and regarding commitments. But unfortunately, it's going to affect some people, you know, whatever way we do. Thanks very much, members, for speakers for attending tonight. Much appreciated. Feel free to leave. Okay. Okay.
Our officers will be fine with any time of the day.
Oh.